Adjournment request, if any, from item number 1 to 5, from item number 7 to 15. Item number 7 to 15, adjournment request.
15 में add करो।
From item number 16 to 27.
My pleasure, Lordship. Lord, the item number 19 may kindly faster for the day.
My pleasure, Lord. Lordship, I beg to mention item number 26 to 29, Lordship. Lordship, the senior standing counsel, Mr. S. Chetia, is out of station, Lordship. And we already informed the appellant day before yesterday, Lordship. And appellant side is also present, Lordship.
Your Lordship, if I might say something. Your Lordship, this matter was entirely heard on 6th. It is a covered matter. They have conceded before the Honorable Delhi High Court that the issue has to be decided against them. I have placed that order on your Lordship's bench. I will wait for my turn. Let the turn come, please here.
Who is the counsel for that?
No, Lordship, actually, he is some urgency.
Who?
Mr. S. Chetia, the standing counsel of Income Tax Department, he went to his hometown due to some personal difficulty, urgency arose. Lordship,
Your Lordship,
Lordship, any date.
I'm traveling from Calcutta.
Already-
I came on 19th also. The matter did not.
Already we informed them day before yesterday, Lordship.
Advocate is there.
You were informed in advance.
Whether
Yes,
you-
I was called that he has some difficulty, but the matter was 6th for today. That's why I traveled. Sir, you have heard the entire matter on 6th.
We have heard, but now if we have granted time and if the
Lordships, I am in your hands, sir, whatever you.
so if you want that ex parte order get passed, then we'll pass that order. I think so. It's a hearing matter, so at least if having some personal difficulty, what can be?
Okay, your
As
Lordship.
we are here to decide the matter, and we are ready for that.
I bow before the decision of the bench.
But sir, you just if some personal difficulty is there for the council, how can we ignore it?
Okay,
Which date? Now you
any date convenient, sir, I am willing to come.
no, that's for your convenience because you have to come from Calcutta.
Sir, it is convenient any date. Sir. I will bow before the bench, whatever date.
17th September.
Okay. Alright.
May I please, your Lordship? Lordship, with the consent of the other side, I beg to mention item number 16. The learned counsel, Mr. O.P. Bhatti, is out of station at Rajasthan for sudden demise of his brother-in-law.
Adjourn.
May I please your Lordship?
Adjourn.
May I please your Lordship? With the consent of the other side, I would like to mention for adjournment item number 20 of today's list.
Lordship, I'm with the petitioner. Date may be fixed for hearing.
Is in the hearing. Adjourn.
Any other request?
May I please, your Lordship? Permission for listing the intercourt appeal lawsuit tomorrow.
Tomorrow? Tomorrow not. Next week.
Supplementary list for admission item 30.
But I've got the instruction.
Lordship, may kindly see page 3. Focus दिया है तो फोर्टीन का प्रश्न नहीं अल्टीमेटली दिया है कोई काम नहीं
Considering the conduct of the appellant, on 13/8, the so cause was issued by the Director of Medical Education. On 14, the judgment came, whereby he was held to be not qualified. So we could not proceed. So thereafter, the appellant himself.
Just a minute. Yes.
Yes. My lord, this respondent, they have come up with an affidavit also where they have annexed few documents. In fact, those are the documents which were placed before lordship yesterday. Now, my lord, lordship will kindly mark two date. 11/7/24 was the date when the work order was issued to our client. 11/7/2024.
Yes.
And the supply was to commence from 16/7. Now, if your lordship would kindly come to page number 366 of the affidavit which has been filed by the respondent.
You don't have that copy.
Yes, my lord. Now, there was a show cause notice to which we replied. We are very much surprised after receiving the above mentioned show cause notice from your office. And specifically, it was mentioned that multiple instances of inadequate supply. Sir, in this regard, we'd like to inform you that we have received a copy of the approved rate from the Directorate of Medical Education for supply of LMO from 16/7/24 but the previous supplier, that is the respondent, stopped supplying LMO from 9th of July 24. The day tender was open and our company Meghalaya Oxygen Limited was L1 in all zones 1, 2 and 3. Though there was a cabinet approval for previous supplier to continue supply of LMO till 15/7/24, still the previous supplier stopped supply. Now they are talking of human lives. Their contract was subsisting till 15. They stopped supplying from Milord 11. From 10 to 15, we have supplied total consignment on verbal confirmation from GMCH, operation in charge is so and so. Then Milord will kindly come to page number 369. Sorry, 368. This is a communication by us to the DME on 10th of August. Please come to the first subpara. Sir, due to some technical problem in the manufacturing plan of our supplier, SD Cryogenic, from whom we have been supplying the liquid medical oxygen, there will be interruption in production and supply of LMO for 3 days. That is 10/8/24 till 12/8/24. The supply will be regularized from 13/8/24. Incidentally, my lord, what had happened? This continued for another day. That is up to 13th. We could not. And 14th, the judgment came.
After 16th or
Ye-
15th.
We are supplying, yes.
Up to 30th.
Yes.
13th of August.
Yes, we are supplying, my lord. And we are in a position, but for the order of the learned single judge, then they stop. Thereafter, as a L2 bidder, they have an obligation, they were asked to supply. Now, my lord, in June, when they were, my lord, operating the contract, they had issues in, my lord, production. So now I'll just, Lordship will kindly have a look at this. There are only 2 manufacturers, my lord. Now kindly see, my lord, 21st of June, he writes because he had some issues in production in his plant. Good evening. How are the productivity available now? These days we are having a lot of nitrogen orders for refinery. So as of now, we can't accommodate any nitrogen. For oxygen, if you need, I can definitely check. Okay, what would be the price for oxygen? X plan, quantity 20 metric ton per day. This is the requirement of GMCH. Any update, please? Good evening. We didn't have never responded, Milord. I want to speak to you. Good morning. How are the
These are
productivity?
the conversation between whom?
This was there, they had issues in June, Milord, when they were operating, because I came into this scene on 11/7. Prior to that, they were the contractor. So they also had some issues, my lord. So they were asking for, oxygen from us. No, what I'm saying is, my lord, the projection which was given yesterday, that I am a person who is not in a position to make
So
supply.
this show cause notice speaks about.
No, I'm not saying no, my lord. Show cause notice was issued. But look at the circumstance. They had a subsisting contract up to 15th of July. Why they abruptly stopped on 11? So, my lord, therefore, when you spit in there, falls in our own head. Therefore, it doesn't help anybody. Now, the question is, now, my lord, we have challenged the learned single judge's order. We say the learned single judge committed an error. First, on merit, my lord, that clause 4 of the terms and conditions is the special terms and conditions. That is, my lord, wrong observation made by the learned single judge. That couldn't have. Secondly, my lord, how the learned single judge could have directed when there was only one eligible tenderer, that the contract should be given to the other party. The authority could go for retender also, there being only one, valid bidder. How the learned single judge could direct that? So, my lord, all right. If I have faltered in supply, it could be a case for cancellation of my contract. I'm not on that. That will be a different subject matter. What I'm on is whether the learned single judge was correct in evaluating the contract in the manner it has been done and giving direction for, awarding the contract to the other side. And the more importantly, my lord, the issue in merit which falls for consideration is, which is decisive. Clause 3 of the special conditions of contract. or clause 4 of the general conditions of contract. That is the issue on merit. And yes, my lord, because there were technical issues in the plant, therefore, for 4 days there was disruption. That I am not disputing. And from 14 because of the learned single judge's order. So therefore, to say that I am unable to supply, now I am supplying, this is not correct. Please come to one page, my lord, kindly see, that will show the conduct of the other side. Please come to page 369. They're speaking of, my lord, our.
Mr. Chaudhary, when was the writ petition filed? Do you have the date?
1 second. Sir. Huh? What is it? Okay, this is next one. My lord. Hmm? That would be like. Yes. Hmm?
File on 16/7.
After the work order was issued to the, so technical bids evaluated,
Financial bids also
both
evaluated.
parties found to be technically qualified. Financial bids opened, he was found to be L1 bidder, work order issued, supply commenced. Then it runs into rough weather. At that stage, writ petition filed saying that he was not technically qualified.
What had happened was, I'll face the fact, what they did was, on 9th, the technical bids were open. They upload it in the website, simply saying that evaluated. They don't even mention who is qualified, who is not. Then we suddenly come to know that on the very next day, they open the financial bid.
No date was fixed for opening of the financial bids.
Dates were fixed, but they were deferred. No work order as such was issued. What?
The date, I think, was in that standard document, they must have mentioned the date that the technical.
The original date got deferred.
Will be opened on so and so date and the financial bid would be opened on so and so date. That was
It
there.
mentioned, but if your lordship will kindly come to page 89, that is the NIP.
Yes.
Please, sir. Please, sir. Please, sir.
Your lordship will find that page 89, bid opening date is mentioned as 3/7. But it was not opened on 3/7.
3/7. And it was open on.
It was actually opened on
9/8.
9/7. And what they uploaded was at page 109, your lordship will find that.
Just a minute, this technical opening of technical bid date was 3/7.
It was notified as 3/7.
And the financial bid on the very same day or the next day?
Same day,
Same day. The technical bid as well as the financial bid are to be opened on the very same day, that is on 3/7. And they opened it on 9/7.
9th. And what was
And financial bid
financial bid was 9/7,
on same day.
same day.
Okay.
And the mischief they did was at page 109.
Yes.
This does not reflect anything about the technical evaluation.
All right. Now, was the work order issued to the appellant set aside by the learned single judge?
Yes, please.
Yes,
Where is that?
firstly, my lord, I must also point out to your lordship. If your lordship will kindly come to page 145, what they claim to be the work.
11/7. Page 354. The interpreter wrote 11/7.
They have interfered, my lord. Page 354.
The work order is dated 11/7.
Yes.
Your lordship will kindly come to page 145. Whether at all this can be, what they do is again very interesting. This was issued on 11/7. The WhatsApp message. The WhatsApp नहीं रहा.
Yes.
On 11/7, this was issued at page 145. So this is not even a work order. This is the authority which invited the tender.
They approved the rates.
They have just approved the rates. And if your lordship turns the page, your lordship will find that the copy is marked only to the appellant, not even to me. When I come to know that this is what is happening, immediately I challenged it, including this document, and the technical evaluation itself was put to challenge. At page 146, your lordship will find that this is marked only to the appellant. So virtually everything happens behind our back. As soon as we come to know, we put it to challenge. And my instruction is that
Financial bids were open of both the parties.
yes,
Then why there is a direction to open the financial bid of your client?
direction is not to open the file.
Consider the case.
Consider.
Consider it. If
Yes.
my lords will kindly allow me to just place the basic background facts. If your lordship will kindly make a note of a few dates. There was an NIT issued on 8th of May 2023. There are certain conditions, like in all.
That you have mentioned.
Now, he does not qualify. He challenges it.
That may
No,
be-
no stay, repetition pending.
Uh,
Now, your lordship will kindly.
Those are the facts may have relevant for that, but here now the question is whether the learned single judge was right in holding that the clause 4 of the terms and conditions is equally applicable. Not only the clause 3 of that service that agreement or whatever.
I'll address your lordship
That
on that.
is-
If your lordship will kindly come to the NIT. Let us examine both the clauses, my lord. If your lordship will come to the NIT, which starts at page 89.
Mr. Chaudhary, we appreciate what you are arguing. We are looking at the matter from two different angles. In fact, perhaps there are two different verticals of this controversy. Number one, whether the technical bid evaluation was valid in the eyes of law. If it is not, as the learned single judge has held, then it has a cascading effect and will vitiate the entire process. That has been done. Whether that is correct or not, that will require deeper consideration. That cannot be done today. This is one angle. The other angle is after the work order was issued, there was a proceeding initiated against the appellant by the director himself. Show cause notice issued, he has submitted his reply. If that reply is not found to be satisfactory, this could even lead to, ordinarily it could have led to termination of the contract. But that, the cart is now before the horse. The contract has already been terminated in the sense that the work order has been set aside. So that show cause proceeding has become redundant without even going into the merit of the claims and counterclaims of the parties insofar as supply and failure to supply of oxygen is concerned. So that is the other aspect of the matter. Now, the appellant may say that when a show cause is issued to me, I have made a reply. The employers ought to have looked into it on merits, and then if they find that I have a genuine reason, the matter is different. If they are a defaulter, then the question of allowing them to supply doesn't arise. That is an aspect which is squarely in the domain of the employer. So there are two parallel domains which have been fused in this order.
In fact, my lord, to address your lordship on that issue, these documents which the appellant has very obviously.
Just a minute, just a minute. Now, you see, Mr. Chaudhary, Mr. K.N. Chaudhary cannot probably oppose that the show cause notice has to be brought to his logical end. That he cannot oppose. Whether he has a justification, that is another matter. At the same time, it seems the director has already decided to make a stopgap arrangement by going for price negotiation and giving you your client the contract. Let that arrangement continue. We'll decide the matter.
Yeah.
What is the problem?
Because in any case, he cannot supply. He has surrendered.
That's all right. The director has.
In fact, the compiler.
Just a minute. The director has already given us this letter, instruction in which it is mentioned that he is going for a price negotiation with your client and is making a temporary arrangement. There are only two bidders. Since there is a show cause notice when his work order has been set aside, the question of letting him supply as a stopgap cannot arise. So that means only your client can supply. Let the interim arrangement continue. We'll hear the retake will finally. What else is there here?
Just two things I would like to.
My lord, whether I have surrendered or not, I think my learned friend is more equipped than.
Yes.
At least our client has not informed anything. He is more informed about my compatibility.
I am, unfortunately, I am.
Please come to me, Lord, page 369. Please come to page 369 for a moment. Now, this letter was blown out of proportion yesterday. Let us read it once again, Milord.
Yes.
So, Mr. Chaudhary.
No, I don't know. Lots will kindly have a look for a moment, just two paragraphs.
Which letter?
Page 369, Milord. Our clients wrote a letter to the Chief Minister. It is our inability or it is our concern. Kindly see, Milord. First subpara. Sir, due to technical issue in the plant, our plant has shut down and the spare part which was supposed to reach few days earlier from China is reaching on Tuesday. So we are unable to start the plant at the present stage. Sir, in the meantime, we have requested L2 Messrs. Premier, that's the learned friend's client, to us or to government hospital, but they have not given any response. And verbally, they have told the rates given by L1 is very less and they cannot supply LMO at this stage. But this is important. Sir, the party in Premier Cryogenic is supplying LMO to AIMS Guwahati at 11 rupees 67 per kg, whereas present rate, DME rate for LMO is 14.25 per kg. Sir, I request you to kindly give instructions as many human lives are at stake so that L2 Premier Cryogenic Limited can supply LMO to government hospital at our plans, and it will take 2-3 more days to complete. In the meantime, my lord, on 14th, the order came. That was the reason why we could not proceed with the supply. Now, all that we are saying is you are supplying at 11 rupees to AIMS. Why can't you supply to Guwahati Medical College at 14 rupees? So therefore, my submission is, my lord, all that is sought to be projected is not correct. When they were in trouble, they requested us for supply. It happens. There are only two suppliers, my lord, two plants in this state. So therefore, my lord, both rely upon each other. Now, your intentions were so good. Why you abruptly stop supplying on 11? because your
That's
technical,
all right. That's a.
therefore, my lord,
That is a interstate.
Yes.
dispute Between,
yes.
we are not entering that.
In fact, my lord, having regard to the human lives involved, I'm not even opposing that. I can also pray for stay of the impugned judgment, which I'm not doing. So therefore, my lord, lordship will fix a early date. Present arrangement may continue for about 2 weeks or 3 weeks, my lord. In the meantime, lordship.
What is the present arrangement? They are-
Present arrangement, my lord, they are supplying. But I can also supply, my lord. Subject to what we
As a temporary measure, they can also ask. you to
Yes,
supply.
yes,
That
yes,
is
we'll
the-
also ask,
Up
yes.
to the state government,
Hmm.
not for us.
Just two things I'd like to, before your lordships, if your lordship will have that good morning, good afternoon WhatsApp message. This does not have anything to do with oxygen. This is pertaining to nitrogen. So these kinds of good morning, good afternoon WhatsApp messages I can produce in thousands. And if your lordship has a look at the compilation placed by my learned friend, they have
So now
accepted.
these pleasantries also have been stopped.
If your lordship will kindly come to page 5 of the compilation.
Mr.
After
Chaudhary,
this
it's time to say good night now. on that.
Your lordship will just have a look at page 5 of the compilation that was placed by my learned friend. This is a letter written by the appellant.
Yes, fine, compilation then and what is part of that? Of Buddha is a Madia nine.
Which arrangement will be subject to further order? That's the.
The
Your lordship
controversy,
will just have a look at page 5 of the compilation.
yeah,
That is a letter written by the appellant to the director. Your lordship will just have a look at the contents.
yeah. What is this letter?
The compilation handed over by
What
my
is this
learned,
letter?
page 5.
Yeah,
This is a letter written by the appellant to the director. Your lordship will kindly peruse the contents.
yes.
With reference to the subject cited above, we would like to request you to kindly take decision in the light of the Honorable Guwahati High Court's order dated 14/8/2024. They have accepted the learned single judge's order. Looking into the emergency of the liquid medical oxygen and human life, we would like to request you to kindly place the order as per Honorable High Court direction order.
They are not requested, they are not accepted. They have simply said, "Okay, since the order is there, now you. uh, The controversy involved in this case is regarding award of contract of supply of liquid medical oxygen,
Bracket 11.
LMO in bracket, to the appellant by the state respondents. Full stop. The award of contract to the appellant was challenged by the private respondent herein, and the learned single judge has set aside the decision of the respondents of accepting, of declaring the technical bid of the appellant as responsive, and has further passed an order, and has further directed to set aside all the subsequent consequential actions such as issuance of work order, etc. The learned single judge has further directed the state respondents to consider the case of the petitioner for award of contract, taking into consideration his financial bid amount within a period of 10 days from the date of the receipt of the impugned order. Full stop. Having heard the learned counsel for the parties, we are of the view that since the issue involved in this case is regarding supply of liquid LMO to the hospitals of the state of Assam and is of urgent matter, the case is required to be heard finally at an early date. Stop. Issue notice. Learned counsel, Mr. So-and-so accept notice on behalf of the respondent, number 1 and 2. 1 and 2. And Mr. So-and-so, Mr. I. Chaudhary, Mr. So-and-so accept notice on behalf of the respondent number 3. Service is therefore complete. List this matter for final hearing on 23rd of September 2024.
Can it be 25th, now? 23rd, I have to be in Itanagar.
25th September 2024. In the meantime, the direction issued by the learned single judge to consider the case of the private respondent for award of contract as per his financial bid
26
is stayed till next date of hearing. The respondent state is directed to make all alternate arrangement for uninterrupted supply of the liquid medical oxygen in the hospitals of the state of Assam as per the arrangement,
Ongoing arrangement.
as per the ongoing arrangement.
My lord, we may be given liberty to make requests. They may consider, my lord.
For the ongoing temporary.
As per the ongoing temporary arrangement, the temporary arrangement till next date, the said directions are subject to the further orders passed by this court. If you want, you may apply before being considered.
Yes.
Apply.
Deeply.
For hearing, item number 1.
Mr. Day, it would have been nice if this matter was heard in Sikkim and we all went to Sikkim.
Truly, my lord, and the
Excellent
previous
climate.
case,
Huh?
I was just wondering, my lord, a day has come when we have to buy oxygen and my lord, and quarrel over it in the court of law.
And my lord, I doubt whether he can provide us the hospitality. At Sikkim.
No,
I can appreciate in Tripura, my lord.
No, but planes are flying, my lord. Pakyang Airport is operative as of date. It's a nice place, my
Justice
lord.
must
Only
not
that,
only be done, it must be seen to be done in Sikkim. That's why.
my lord, yes, the atmosphere here, my lord, with the ambience here, my lord, is better than the Sikkim ambience. The court ambience, I think. My lord, the matter being from Sikkim, yes, on the lighter side, I've always told my lord that at this age, my lord, I'll like to step up a little slow move. But my lord, everything said and done, for me, it's a learning process because, my lord, this is one territory which came to be a part of the polity of our constitution post 74. So law is different, my lord. My understanding of law, my understanding of Article 14, my lord, it saw new light in this case, in other cases of Sikkim, my lord. My lord, normal canons of understanding takes a halt when it comes to Sikkim because law is different, my lord. Law is different and those laws have been by means of Article 371K adopted. Some laws, the ethos are alien to us. So, my lord, it took me some time to understand this case. My lord, for me, it's a learning process, it's not a process of really taking your lordship to Sikkim. I will just assist your lordship in this case, my lord.
For all of us, sir.
My lord, my lord, Honorable Single Judge's order start at page 41. My lord, I will just read one line of that judgment. And my lord, to understand this first line, we have to go to the facts of the case. And I'll confine myself only to the, my lord, annexures of this writ appeal, which are parts of the pleading. My lord, page 41 for a moment.
Like Mr. Day, good for the day, you'll consume the whole day?
My lord, not whole day, my lord, with this court, probably 1.5 hour of uninterrupted hearing, 1.5 hour. Then, my lord, Mr. Chaudhary, I think, my lord, I'll endeavor to complete within the first half, my lord. Because I'll go a little slow, my lord. My lord, the gamut of the case can be understood. Is one of the best written judgments, my lord. I may not agree with the reasons part. It is one of the best written judgments I've seen, my lord. Page 44, my lord. Page 44, that's the Honorable Single Judge's order.
Starts from
Page 44, my lord. It starts at page 44. My lord, this is volume A of the compilation. Volume A, which is the writ appeal. Lordship got it, my lord. My lord. This is WPC 66 of 2016. And it's a judgment in order dated 20th of February 2020. My lord, the petitioner number 1 to 15 are grandchildren of government servants to the government of Sikkim prior to 31/12/1969. Meaning thereby, my lord, persons who were the government of Sikkim servants prior to 31/12/1969, the petitioners are their grandchildren.
1 to 15.
My lord, 1 to 15. My lord, petitioner number 16 to 21 are the children of government servants of Sikkim on or before 31/12/69. Petitioners are agreed by the state of science society. My lord, facts will come a little later. If your lordship wants to see the, my lord, they basically came, if I understand correctly, to vindicate their rights of equality in employment and other allied rights. My lord, they want to see Article 14 in that line. My lord, your lordship will kindly see the, just for a ready reference, nothing more. My lord, the concluding part, my lord, conclusion of the judgment, which will speak of the prayer and the prayer granted, both. My lord, kindly come to page 91, inner page 48 of the judgment.
Yes.
There are 40.
Yes.
39 is in conclusion, the consideration of facts and circumstances, documents on record, gamut of the discussion above, the question raised supra stand answered. In conclusion, it is observed and ordered as follows. 1, the insertion of the sentence certificate of identification obtained by such persons shall be for the purpose of employment only, appearing in notification number so-and-so dated 22/11/1995. My lord, for a ready reference, your lordship may just write page 195. I'll take your lordship to that. This page 195. And insertion of the sentence certificate of identification obtained by such persons shall be for the purpose of employment only and for no other purpose, appearing in the notification dated 27/9/1996. My lord, page 197. Substituted item number 5 of the notification dated 22/11/1995 being irrational and violative Article 14 of the Constitution deserve to be and are hereby quashed. Letter bearing so-and-so dated 2/6/2006. My lord, this is page 199, 199A. Issued by respondent number 2 to the effect that item number 5 of the notification dated 1995 does not entitle the third generation, that is the children of the persons who are issued certificate of identification on the basis of employment of their father in the government of Sikkim before 31/12/1969 to obtain COI, my lord, certificate of identification, is unconstitutional, abridging the fundamental rights of the petitioner under 14 and 21 of the Constitution, hereby quashed. Next, state respondents, their agents and servants are prohibited from giving effect to, my lord, the supra notification 26/2006. Then, my lord, insertion of item number 4A of the notification in 1995 below item 4 above item number 5 by the notification dated so and so, my lord, 2010, which reads 4A, a person whose father, husband was eligible for grant of certificate of identification under any category or categories listed under item 1 to 4 above or is ultra vires. My lord, that is page 200. This notification of 2010 is page 200. My lord, may skip and come to 4 below. That descendants of the persons who have obtained COI on the basis of their father being government servants in the government of Sikkim prior to 31/12/1969, falling under item number 5 of the notification dated 95, then item number 5 of notification of 96 are entitled to obtain COI, certificate of origin. This is identification. This also includes the third generation and their subsequent generations. So, my lord, by and large, one thing is clear. These notifications, which are prima facie limited to wife and children of persons who were serving up till 1969, now stand extended by court's fiat.
Wife and children, not only wife and children.
My lord,
In fact, why this petitioners number 16 to 21, who are the children of the government servants, are also agreeing?
kindly see, petitioners 16 to 20 are the children of the government servants to the government of Sikkim on or before 31/12/1969.
If, as per you, the wife and children are entitled for COI, then why these persons have approached the court?
My lord, kindly see, then these persons just join themselves because these rights are already available to them. These rights are otherwise available to them. They just join themselves. Crux of the matter is 1 to 15.
Then where was the need for them to approach the court for what purpose?
Absolutely none. I don't understand that. They were probably, my lord, by way of my lord, to show, my lord, probably there are so many persons aggrieved. Because your lordship will see, whatever has been extended to them, they already stood extended.
Visiting all the respondents?
Yes, yes, yes.
So why these persons 16 to 21, who are the children of the government servants, have approached the court? For what?
They have also been denied the benefit, my lord.
By which notification?
Yes, I'll show.
Which notification?
Yes.
There is one leg of their argument. I'll come to them.
Just
my lord.
just to clarify.
Yes, yes.
1 second, my lord. I'll just give it.
It was confined to employment only. For their relief, it will be, my lord, that it doesn't.
Basically, what we understand till now that the writ petition is by the persons who are the grandchildren of the government employees of government of Sikkim prior to 31st of December 1969. That those persons had grievance that they have been left out or whatever it may be. But if you are saying that the wife and children, their rights are protected, then why they have approached the court?
Yes, they want extension of the benefit of those notifications beyond for the purpose of employment only.
That may be
My lord will first come to page 187 to understand it. my lord.
187.
Yes.
Yes.
In modification of this department's memorandum dated 25/9/76 and dated 28/1/80, the governor has been pleased to authorize district collector within their respective district to issue certificates to person identifying them in the following group to enable them to apply for employment of the state. A person whose name is found recorded in the old Sikkim subject register prior to 1975. A person whose name is not found in the register, but she has established beyond doubt that the name of his or father, husband, paternal grandfather, brother from same father has been recorded in the old Sikkim subject register. Person whose agricultural land in rural areas has been ordinarily residing in the state 4 A person whose father, husband had been in service of the government on or before 31/12/69. Now, my lord will kindly come to page number 194, my lord. November 22nd, 1995. Page 195.
195.
Yes. In supersession of the memorandum dated 25th of September, etc., and 9th of April 81, the one I read, and circular, etc., the state government is hereby pleased to authorize district collector, subdivisional officer, and revenue officer within their respective jurisdiction to issue certificate of identification to persons falling in different categories as indicated below on recommendation of the Gram Panchayat being duly satisfied with such recommendation. Now please come to 4, my lord. A person who is holder of an Indian citizenship certificate issued by the district collector, governor of Sikkim under Sikkim citizenship order as may be so and so. 5. A person whose father, husband has been in Sikkim government service on or before 31/12/69, certificate or identification obtained by such person shall be for the purpose of employment only.
So you are agreed by this that
No,
they
no,
have confined,
Huh.
they have confined
To employment.
only employment and no other benefit.
No other benefit, but otherwise, my lord, by virtue of that 81, we are getting everything.
Everything, yes.
Yes. Now,
a
now,
supersession
gradually what they do, then my lord, this 195 is followed by page 197.
Here they have added one more line, no other purpose.
No other purpose. So therefore, it's not a case where we are fighting for our employment right. We are seeking, actually, my lord, when I make my argument, I'll satisfy. We are deemed citizen, my lord. Because that regulation of 1861, that was, my lord, repealed. But by virtue of, my lord, Article 367 of the Constitution, read with Section 6C of the General Clauses Act, those have been saved. So these are our vested rights. How can it be taken away by these executive instructions? My lord, in terms of clause G of Article 371F, the governor must exercise the power. My lord, those notifications that this notification has been issued under the signature of the governor, my lord, they could not produce. Not only before the learned single judge, even before this honorable court, my lord, on several occasions time was taken, they could not produce. They are relying on Surendra Prasad Sharma. Surendra Prasad Kumar Sharma was in a different context. That was a case, my lord, under Rule 4.4, in case of employment, some benefit was given to locals. That is because, my lord, in terms of Article 16.3, that is permissible. If there is a parliamentary law, what is prohibited by Article 16.2 can be undone by Article 16.3. So here is a case we are not only fighting for our employment right, we are fighting our right that we are deemed citizens of Sikkim. That is our case. And my lord, our right has been saved. And by an executive, what a vested and deemed right, can it be taken away by an executive order? That is our case. Even that is an aspect which was not even considered by the learned single judge properly. I would respectfully submit better. So it's a case, my lord, is a very, very important and a very sensitive issue concerning, my lord, citizenship. And my lord, the Citizenship Act was adopted. And my lord, there is a deeming provision also. Anyway, when I make my submission, I've just given the outline of what I would like to add.
Now there are two set of persons.
Yes.
One, the grandchildren who are excluded from all the benefits.
Yes.
And another set of persons are children of the
Government servant.
employees of the government of Sikkim prior to 31st of December 1969. as their rights are confined only for the, up to the, for employment only and no other benefit have been derived.
My lord, for greater clarity, Lordship will kindly give me 5 minutes time. Please come to page 96. Two ways citizenship could be acquired under this regulation of 1961. That is by my lord birth and by naturalization. Please come to page 96. We say our right flows from this. This clinches the issue, my lord. 96, naturalized subjects. Now please come to sub-rule 3, my lord, subsection. Governor, His Highness shall have the power to naturalize a person upon application made therefore in the manner prescribed by the rules, provided that the government of His Highness are satisfied that he has been in service of government of Sikkim for a period of not less than 10 years, immediately preceding the date of his application. 2, he has rendered meritorious service to the state, and person to whom such certificate is granted shall, on taking oath of allegiance and upon his name being entered in the register of subjects, be naturalized Sikkim subject from the date on which this certificate was granted. My lord, from this scheme of this 1961 regulation, what will be evident, my lord? The right to acquire citizenship by rendering service to the government was kept on a higher pedestal than by birth. Because here, my lord, no qualifying period is also required. All that is required is on the date I make my submission, application, that I must have put in 10 years of service. And as far as, my lord, naturalization is concerned, please come to, sorry, by birth, page 94, my lord. It says, B has ordinarily been resident in the territory of Sikkim for a period of not less than 15 years immediately preceding such commencement. That means by birth, if one is to seek citizenship, then before 3761, he must show that he was in Sikkim for a period of 15 years. But in case of government servant, the considerations are much more liberal.
No, A says was born in the territory of Sikkim and is resident there.
We are not covered by this, my lord, not by birth. We are seeking by naturalization because our grandparents, my lord, our parents, they have served the government of Sikkim. And subsequently, my lord, Citizenship Act, when it was amended, adopted, my lord, in terms of 371K, then, my lord, there is a qualifying provision. We also meet those. And this is our broad outline, my lord.
Mr. Chaudhary, just for understanding,
Yes.
because he has just begun. Your argument is probably that you missed out, you have left out number 4.
I'm sorry.
Number
sir.
4 deals
Page
with the,
96.
One second.
page 96, number 4.
Fourth, Government Highness may at the same time naturalize the wife and minor children of a person who is granted certificate of naturalization. Yes,
Okay, so it must be your case that the naturalization kicks in with under this regulation of 1961.
yes.
And once the conferment is complete under this, then the Citizenship Act will kick in to control the rights of the progeny, the
In fact, my lord, please,
grandchildren. Is that
Yes.
the argument?
yes.
We're just trying to answer.
Just one more document, my lord, that will again clarify the issue further. Recon control, citizenship or recon. 1 second, my lord. Citizenship or amendment to. Yes. If your lordship would kindly. Yes, no, no, yes, this would be yes. Please come to page 178, my lord.
Yeah. And once they get a citizenship, their subsequent right to be governed. That is the ambit of this controversy. Looks like.
Yes. Page 178, my lord. This is the Constitution 36th Amendment.
170?
178, my lord. If your lordships, it is an notification issued by the government of Sikkim, but the relevant government of India notification is towards the bottom, my lord. That SO 217E.
Yeah.
In exercise of the power conferred by Section 7 of the Citizenship Act, central government hereby makes the following order, namely, this order may be called Sikkim Citizenship Order 1975. Every person who immediately before 26th day of April 1975 was a Sikkim subject under the Sikkim Subject Regulation 1961 shall be deemed to have become citizen of India on that day. And next page, if your lordship comes, when this adaptation order was issued, when Sikkim, that regulation of 1961 was repealed, but by virtue of my lord, kindly see, the order may be called adaptation of Sikkim laws order so and so. Please come to 2.2. General Clauses Act 1897 applies for interpretation of this order as it applies for interpretation of the Central Act. 4. As from the appointed day, law mentioned in the first schedule to this order shall stand repealed. Next page, that is the Sikkim Subject Regulation 1961 repeal, but by virtue of Clause 6C of the General Clauses Act, read with Article 367. My lord, it is saved. So therefore, our rights are rights. So by virtue of that, my lord, they should have recognized us as Sikkim subject, which they have not done. That's why we're before the
So
court.
what are the other rights except for?
Everything, my lord, right to property, everything. Now, my lord, we are not even getting a driving license. It has gone down to that.
So according to them, your clients are citizens of which country?
No man's land.
They
My
are,
lord,
they are neither citizens of any other country nor of
Sikkim, the north of India.
nowhere, no man's land, that's why I said, my lord. Even I can't apply for a driving license, that is the state. So many, during the pendency of this proceeding, my lord, though initially there was a no stay order, so many recruitment process, was initiated, we could not take part. I think, my lord, the learned single judge view is absolutely correct, but I, subject to correction, my lord, I feel learned single judge also should have taken note of this vested right concept and this implication of Article 367. Yes.
My lord, as conventionally told, whatever flows from the bar, my lord, can be broadly divided between two categories, Sutram and Vaishyam. Code and its ramification. My lord, I will confine myself first to code only, no Vaishyam, because Vaishyam is a safer, my lord, when I leave it on your lordships. The interpretation part is better left to the bench, my lord. I will assist your lordship only to the Sutram part, the code part. My lord, your lordship, by now, my lord, two things are clear. Whose rights are we talking of? This is one question we'll pose large at our face. Who are these people? The people who cannot buy land in a land where they are citizens. Now, this concept is not alien to the rest of India also. I cannot buy a land in Shillong, although it's a very beautiful place, my birthplace, because by law, my lord, land distribution system has been regularized and regularized in such a manner that after that law came into force, there is not even one.
correction, some areas of Shillong.
My
Some
lord,
areas.
it's not some areas. It's -3 words.
यहाँ है कि ये लोग कहीं पे भी नहीं
That's why I agree to his last but one line, Mr. Chaudhary. There's a very pivotal matter which really needs a consideration by the court, some of which were left out even by the honorable single judge. I agree to that.
That's right.
Right.
That's right. But that's what you have projected that many persons can't buy a land in Shillong or somewhere else in Meghalaya,
My lord,
some part of the so and so.
not some part.
That is for that is for those persons who are bona fide resident of another state.
No.
Yeah.
No.
non-local.
Because, absolutely. My lord, but for Assam, minus its two hill districts of Dima Hasao and my lord, Karbi Anglong. Karbi Anglong.
There is a restriction in, I think so in everywhere that a land belong to SC/ST person can't be purchased
ST.
by a general person, the general.
By and large here, my lord.
Is there.
By and large, my lord, 6 schedule areas, hill areas, rather under paragraph 20 of the 6th schedule, and 5th schedule areas of Andhra Pradesh and others.
but
By and large, my lord.
in areas also,
Land.
even in Rajasthan, there is a ban for that.
Yes, yes, yes. My lord, I'm aware of it. My lord, no. Same thing. It is not the right of the citizens. Out of the citizens brigade zone, there is a right carved out for Sikkimis and non-Sikkimis. Non-Sikkimis are Indian subjects and very much entitled to all rights minus Article 19 of the Constitution and minus Article 16. Because by law, they can be regulated, which has been regulated. My lord, it can be carved out of that zone of, my lord, omnibus zone of Article 14. This is a recognized law, my lord. Now, that's the case. It is not that they are persona non grata as sought to be projected. They are very much, my lord, I'm making a statement at that they're very much Indian citizens. But just because they're Indian citizens, a person may not be a scheduled tribe entitled to special rights. They may not be Sikkimese subject entitled to some special rights.
But Mr. Chaudhary says they can't even get a driving license.
I don't know, my lord. It's not a
No,
part of the
it's a
pleading.
serious matter.
My lord, it's not a part of the pleading. I cannot, my lord, these are something very new. These are something very new. If it was to such an extent, there would have been pleadings in the writ petition. There would have been some decision here and there. Nothing, my lord. These are just made, my lord, these are across the fence. These are across the fence.
The petitioner is sitting behind Lordship who has been deprived of getting a.
No, very good. You amend your writ
On
petition.
what ground?
Because the COI has not been submitted by him. He could not submit the COI, which is the certificate of
Is
identification.
there any written order for that?
I will send.
These are not parts of the pleadings. I cannot, my lord. I'm
The
sorry.
fact, if it is a fact,
Well, if it's a fact that they've got a right cause of action, even they can come up before your lordship. My lord, Article 226, writ appeal is only an extension of that. I don't say, my lord, it's an individual thing, it cannot, lordships can take, but my lord, for that a pleading will be necessary. Here it is by and large, my lord, confined to employment only. Your lordship will see that. Because after everything, after this driving license and everything, the thing, or rightly so, my lord, has boiled down in the words of Mr. Chaudhary to employment. There had been so many intervening, my lord, recruitments, we could not take part of it. That's the main issue here. That's the main issue. My lord, I'll start again.
Yeah.
No, my lord, by and large, the benefit we get from Mr. Chaudhary is, my lord, he has opened up the preface part. I don't have to address your lordship. My lord, by and large, two issues I have to assist your lordship. Because I will also know in the process, my lord, we will share. The issue of employment and the issue of, my lord, citizenship, or I will say Sikkimese, non-Sikkimese issue. My lord, I will say again, there is no quarrel when it comes to citizenship issue. Whether he is a citizen or not is not at stake. Everyone is a citizen in Sikkim if he is not declared to be a foreigner. Everyone is a citizen if he is not declared to be a foreigner. We don't have de-voter issue in Sikkim. Now, my lord, I will probably, my lord, take your lordship to citizenship issue parts first. That will be easier for me to understand, my lord, what is this employment issue? Why this employment only, why this? My lord, kindly come to page 94 of this memo. My lord, I am not taking a lordship again to Article 371K and all these things. My lord, this is a notification of 3rd July 1961, page 94. It's a Home Department notification dated 3rd July 1961. It notifies the regulation made by the then, my lord, King Chogyal. The Sikkim Subjects Regulation 1961. This is pre-merger regulation, my lord. The following proclamation of Chogyal of Sikkim is hereby notified, whereas it is expedient to define clearly the status of Sikkim subjects and to make provisions for acquisition and loss of the aforesaid status. Now, therefore, the Chogyal of Sikkim has been pleased to make and promulgate the following regulation, short titled Sikkim Subjects Regulation 1961. It shall extend to the throughout the territory of Sikkim. Commencement, the regulation comes to force on such that as may be appointed. My lord, it was from 3/7/1961 that it came to force. My lord, the notification is page 98. I've annexed it. Now kindly see, my lord. Certain persons domiciled in Sikkim territory at the commencement of the regulation to be Sikkim subjects. Commencement is 3rd July 1961. Every person who has his domicile in the territory of Sikkim immediately before the commencement of this regulation shall be Sikkim subject if one.
ये 94 में भी ऊपर लिखा हुआ है 3rd July. ये तो है कि- और ये notification page 98 में है. हाँ.
Did I miss anything? my
It's
lord?
in front of the second floor, yes.
Promulgation के notice.
Yes,
My lord.
yes,
My lord, did I miss anything, my lord? No.
page 98.
Page 98 is the commencement, my lord, notification.
It's mentioned in 94 also in the top.
Yes, yes, yes. At the top, my lord. No, my lord, every person, 1961 is the year. Every person who has his domicile in the territory of Sikkim immediately before the commencement of this regulation shall be Sikkim subject if he, one, was born in the territory of Sikkim and is resident therein, or B, has been ordinarily resident in the territory of Sikkim for a period of not less than 15 years immediately preceding such commencement. So, my lord, a person who is staying in Sikkim for 15 years at least, or a domicile therein, prior to commencement, prior to 1961, my lord, is automatically a Sikkim subject. B, I'm sorry, now proviso, provided that in counting the said period of 15 years, any absence from the said territory on account of service under Government of India shall be disregarded. Or C, my lord, main clause, is the wife or minor child of a person mentioned in clause A or B. Kindly pause here for a moment, my lord. The entire issue stems out of this. The first line of the judgment itself speaks of that. My lord, who is a Sikkimese, who is not a Sikkimese, who is a Sikkimese and who is a non-Sikkimese, is, my lord, here. Provided that a person shall not be a Sikkim, my lord, none of them they claim that they were domicile. None of them they claim that they had prior to 1961, those 15 years of landmark, nothing. Provided that a person shall not be a Sikkim subject under this section unless he makes a declaration to the effect that he is not a citizen of any other country at the time, inclusion of his name in the register of Sikkim subjects shall be maintained under this regulation. My lord, I'll again, my lord, at the cost of repetition, read the first one.
Interrupting you, Mr.
My lord, please.
What happens if a person comes within the ambit of your regulation 2(1) and has a wife and 2 children, 1 minor and 1 major? Then what will happen? Major will not get.
No, both will get.
Huh? But it only speaks about wife and minor.
Wife and minor prior to 61, yes.
Yes. So prior to 61, at a particular date, a government servant who's been working has a wife and 2 children, 1 minor, 1 major. So major will be left out from this.
For the time being, yes. But this was solved post-Indian merger by the Amendment Act of Citizenship, by which a new process was undertaken, your lordship will see that. By which method, my lord, all the left outs were included within the
What is the logic? One family, husband gets, wife gets, minor gets, but the major child is left out. What is the logic?
That's why we have discarded Raja's rule. This is a Rajaka rule, my lord. Togyal makes it. No, my lord. Every person who has a domicile in the territory of Sikkim immediately before the commencement, that will cover everyone. A minor is also a domicile, a major is also a domicile. But the purpose is different. We'll see to it later on. Purpose is different, and this will probably not disturb your lordships later on when the facts issue, my lord. Now, my lord, everything is provided. I'm sorry. Yes, provided in the counting of A and B. C is, my lord, very pivotal. 2, 1, C is the wife or minor children of a person mentioned in A or clause B.
Yes.
But my lord, A covers even others. Was born in the territory of Sikkim. That will take care of everyone. That will take care of everyone. My lord. Rest, my lord, anyway, provided that the person shall not be a Sikkim subject under this section unless he makes a declaration to the effect that he is not a citizen of any other country, and includes his name in the register of Sikkim subject to maintain under this regulation. Provided further that in the case of a minor or a person of unsound mind, such declaration made by the guardian. Explanation: no person shall be deemed to have his domicile in the territory of Sikkim unless. Well, this explains 2, 1, that domicile. Unless he is a person who has made Sikkim his permanent home and has, my lord, this is a typing mistake, not served, severed. Severed his connections with the country of his origin, such as by parting with his property in that country or acquiring immovable property in Sikkim. My lord, a person having property at Kalim.
Yes.
I'm sorry.
Mr. Dev, what is the date of instrument of accession?
74. 74. My lord, I tell the exact date. 1974.
So what was the status of Sikkim in 1961? It was not a part of Indian.
No, it was an independent country. Sovereign independent country having its, my lord, consulate in Delhi, the present Sikkim House.
Yes, but what happens moment the accession takes place, then the Indian law, the post-independent India's law, not the colonial law, would it not have an automatic
Subject to Article 371, especially K. 371.
What is 371?
371, my lord. F. 371 F. This is a special provision in respect of the state of Sikkim. It was inserted in 1975, my lord, by your constitutional amendment. 371 F.
371
F.
AF.
No, only F. F for foot, my lord, football.
132.
71 A, B, C, D, E, F.
Yeah.
My lord, special provision with respect to the state of Sikkim. My lord, to answer your lordship's, my lord, pertinent query, K. Other provisions are also important, but K will probably be all laws in force immediately before the appointed day in the territories comprised within the state of Sikkim or any part thereof shall continue to be in force therein until amended or repealed by a competent legislature or other competent authority. My lord, the other day, a very pertinent question fell from your lordship, which I was not very sure. My lord, that regulation 4.4 Supreme Court was pleased to uphold, where right of employment is reserved to the Sikkimis. The question was, is it a law under Article 309? As of that, the question is yes. My lord, it was a rule pre-merger, which was saved by Article 371 F K. And now, my lord, Surendra Prasad itself says is a rule under proviso to 309 till legislation comes.
Yes, but that brings us to another question. By virtue of Article 371F, will it also not mean that the laws which continued since the days of state of Sikkim would be amenable to scrutiny of the courts under article, on the
Absolutely.
touchstone of Article 14?
Absolutely. Absolutely. Nothing is above Article 14, my lord. Nothing is above your lawsuit.
But when these legislations or the regulations were promulgated, Article 14 had nothing to do with it because Sikkim was not a part of Indian. But moment there is an accession and integration, it becomes a part of Indian law. It will be amenable to scrutiny under Article 14.
Absolutely.
Then
But-
you have to address arguments on how this meets the requirement of
My
Article
lord,
14.
the balance is the framers of the Constitution who adopted Article 371 FK were conscious of Article 14(2), and being conscious, they have taken it within the fold of the Constitution. And the prima facie, my lord, legitimacy runs in favor of these laws now, unless these are specifically challenged and set up not by a court of law. The prima facie legitimacy runs in favor of all these legislations.
That is true for any legislation.
Yes. My lord, but nothing is immune from your lawsuits, judicial scrutiny. Let me say that. Now, but my lord, this will not trouble us where this was repealed. This was repealed specifically. Now, but my lord, although repealed, its effect continues in another manner. I'll show. Because the register under this regulation was saved for the purpose of bringing forward the citizenship register as it exists in Sikkim today, and also defining Sikkimis and non-Sikkimis. Like 1951 presidential promulgation is carried forward to define who is a ST, who is a non-ST. Not a very good example, but a simile. These laws were saved.
No, but Sikkim was not it is not a case of reorganization of states on the basis of language.
No.
It's not a case. It's a
Of
case of plain and simple accession.
Yes.
So therefore, when you say Sikkim and Sikkimis and non-Sikkimis, do you refer to people on the basis of language spoken, or what is the criteria?
Criteria is this law. This law was, my lord, everything done under this law was saved. And this shows the policy of Government of India to protect some of the Sikkimis original culture ethos and, my lord, the rights of the Sikkimis people who were taken to the main fold Indian.
That's right. So how do you define who is Sikkimis and who is non-Sikkimis?
That's it. My lord, the answer will lie here. My lord, there's a gradual growth of this law. We'll see to it. How Indian law has accepted this. Now, my lord, there are some criteria your lordship has seen. I'll not go to the criteria. They are not challenged before your lordship. That the criteria also stops at minor child and wife is also not under challenge. Is also not under challenge. My lord, my lord, page 95, that severed your lordship has seen. If a person has got a my lord, property at Kalimpong, which is the case of one of the petitioners here, I showed in another litigation, my lord. It's not a subject matter here. I'll not trouble your lordship, but I can tell your lordship. It's a part of a pleading before the High Court of Sikkim. A person was, my lord, evident that he was a Indian subject, British India subject, having his properties, permanent properties at Kalimpong. He had not severed. That's why he was denied citizenship right under Sikkim in those days. He applied for Sikkim's citizenship. He was denied that. He was told that this is the proof against you. He could not deny that. No, my lord. provided that a person shall not be deemed to have a permanent home in Sikkim if he indicates an intention of returning to his country of origin. Then, my lord, the wife and minor children of a person having his domicile in Sikkim shall be deemed to be domiciled in Sikkim for the purposes of this section. Then, in the case of doubt as to whether the person the domicile in the Sikkim, the matter shall be decided by the Chogyal appellate provision. Certain persons, though not domiciled in Sikkim, to be Sikkim subjects. Any person who has not voluntarily acquired the citizenship of any other country, though not domiciled in Sikkim, may on application made to the authority in the under the prescribed rule, made under this regulation, be registered as a Sikkim subject, provided he is a person 1, 2, 3, 4. Then, my lord, Sikkim subject by descent. Every person born under the commencement, after the commencement of the regulation, shall be a Sikkim subject if at the time of his birth his father is a Sikkim subject under this regulation, whether or not birth take place in the territory of Sikkim. Status of women married to Sikkim subjects. My lord, ordinarily offending Article 14. But anyway, it was given up, but still kindly see. A problem which plagues most of the part of India. Even Kashmir, my lord, this right was reserved. Lordship knows till the other day, Article 370. A woman of foreign nationality who is married to a Sikkim subject after the commencement of this regulation shall ordinarily be eligible to be registered as a Sikkim subject on making an application, therefore, to the government of Chogyal in the manner provided under this regulation, and for renouncing her former nationality on taking oath, provided the Chogyal, after giving reasonable opportunity of representation, may refuse such application. Certain persons not to be Sikkim subjects. Kindly see. A person who denounces his status as Sikkim subject or voluntarily acquires citizenship in any other country, kindly skip. Any Sikkimese woman who marries a person who is not a Sikkim subject. We had this rule even till the other day, my lord, in part of India. Any person other than a person referred to in section 4, whosoever is connection with Sikkim, such as parting his property in Sikkim and migrates to a place outside Sikkim and India after commencement of this regulation, or has not been ordinarily resident of Sikkim for a continuous period of 7 years, shall thereafter be not be a Sikkim subject. So, my lord, my lord.
Yes.
My lord, I'll not disturb your lordships much over the rest of the provisions. They don't exist as of yet, but my lord, we have to take a cue. My lord, I'll refer only to 8 for, my lord, page 96, for a simple purpose.
Page 8.
8. My lord, there are also provisions for page 96. I'm
Page
sorry.
8 or clause 8?
No, clause 8, page
Naturalized-
96.
Naturalized subjects.
My lord.
Yeah.
Lordship, kindly see on the 7th line, there's a mention of a register. Your lordship has seen again and again, my lord. Everything boils down to a register.
In the manner provided under this regulation by full age, capacity, commencement, so and so. other
Yes, yes.
subject Fulfill the requirement.
Yes.
Section so and so of regulation by subject
Subject to grant of certificate of naturalization.
of so and so.
Sir.
And the person whom such a certificate
is
is
granted.
granted shall on taking oath or allegiance and on his name being entered in the register.
Register. Now, my lord, again and again, in the next also 9 also, loss of deprivation, it will be mentioned in the register. Now, my lord, there is a register of Sikkim subjects which is born out of this regulation. That register of Sikkim subjects is, my lord, page 97 for a moment. Why this is
97.
97? My lord, clause 12,
Yeah.
after the miscellaneous.
Evidence of a status.
Evidence of the government of His Highness of so shall maintain a register of Sikkim subjects in accordance with the rules. I'll stop for a moment, my lord, not disturb your lordships further on this. My lord, page 98, your lordship has seen the date of commencement. Next page, page 99, is that, my lord, rules framed under the regulation which speaks of the registrar, how to create it, how to maintain it, all these things. My lord, now there is a regulation which defines who will be a Sikkim subject, and that regulation says all the persons who qualify under this regulation, their names will be entered after scrutiny in a register. What is the register? Register of Sikkim subjects. My lord, now kindly come to page 178.
Is Sikkim subject a defined expression?
My lord, the definition is here only. Sikkim subjects, I'll say citizens of Sikkim. Those who are, my lord, if I can, if in our Indian law parlance we want to understand it, it has to be, my lord, is a sovereign state in those days. So the residents or citizens who had all the rights under that sovereign regime is a Sikkim subject. My lord, a king always wants to call his people by the name of subject, not citizens, subject. So, my lord, but this will be akin to, if we call of a constitutional polity, it will be akin to the term of citizenship. They had all the rights. They had all the rights in Sikkim in those days. My lord, page 178.
Yes.
This is where, my lord, immediately after annexation, my lord, 1975, page 178. How this law was treated and utilized. 178, which is annexure A12 here. This is a Home Department notification of 21st of June 1975. This only quotes Government of India notification. Citizenship being, my lord, a central subject by then in that part of India. The Government of India, Ministry of Home Affairs, by notification dated 16th May 1975, published for general information, SO so and so. In pursuance of the notification, Government of India and the Ministry of Home Affairs, SO dated 16th May 1975, central government hereby appoints 16th day of May 1975 as the date of Citizenship Act 1956 shall come to force in the state of Sikkim. Now, this is very important for us. Next is not important, but still, in exercise of the powers conferred by Section 18 of the Citizenship Act, central government hereby directs the citizenship rules on the shall stand extended with effect from 16th of May 1975. Next is in exercise of the powers conferred under 18(1)(2)(f)(51)(b) of the Citizenship Act, central government hereby directs that the citizens' registration at Indian consulate rules shall extend to and come to force in the state of Sikkim with effect from 16th day of May 1975. Now, next, my lord, will probably require our little more pointed attention. SO 217E. In exercise of the powers conferred under Section 7 of the Citizenship Act, the central government hereby makes the following order. Namely, this order may be called Sikkim Citizenship Order 1975. Every person who is immediately before 26th day of 1975 was a Sikkim subject. My lord, they also use the word Sikkim subject, which is a fallout of the regulation. Sikkim subject, under the Sikkim Subjects Regulation 1961, shall be deemed to have become a citizen of India on that day. My lord, that probably answers the controversy today sought to be raised. They are persona non grata. Who is persona non grata? These are all citizens of India. Is their pleading, my lord? Although that's not under challenge by any party. So, my lord, a person who was a Sikkim subject on a particular date under what? The Sikkim Subjects Regulation 1961 shall be deemed to have become citizen of India on that day. Now, my lord, this was amended. This notification was amended. Kindly come to page 188. No, I'm sorry. 179 also. Next page. Then we'll go to next. 179. My lord, after having used the word Sikkim subject as emanating from the Sikkim Subjects Regulation 1961, my lord, by the adoption order of 1975, with effect from appointed day of April 1975, my lord, kindly come bottom. As from the appointed day, law mentioned in first schedule of this order shall stand repealed. My lord, the first schedule, the second entry is.
Where is that?
My lord, I'm sorry. Page 179, Lordship gets minute.
Yeah,
Page
179.
179. Kindly come to the bottom, my lord. My lord, let me read the.
Mentioned in second schedule of this order.
Shall stand repealed.
Shall until altered, repeal or amended.
Yes.
By a competent legislator so and so. Shall have the, have effect subject to the applications and modification directed by the schedule. Repeal.
First
Until
is
altered, repeal or amended.
yes. 371F. My lord, some are specifically repealed, which are not repealed shall have force. My lord, kindly come to the next page.
Yes.
First schedule.
Yes.
Second entry. Sikkim Subjects Regulation 1961. Lordship got it, my lord? Page 180.
Yes.
That stands repealed.
Okay.
That stands repealed, my lord, because clause 4. As from the appointed date, the law mentioned in the first schedule to this order shall stand repealed. So first schedule, second entry is Sikkim Subjects Regulation that stand repealed.
Yes.
Am I clear, my lord? But my lord, kindly see the legal effect. Although the Sikkim Subject Regulation is hereby repealed, naturally there can be two laws in a single territory. A Citizenship Act has already come to force. But my lord, by the previous notification at page 178, the effect of the regulation is maintained and saved because page 178 bottom, SO 217. This is pivotal, my lord. I'm taking a lot of time because of this. 217E, bottom. In exercise of the powers conferred under Section 7 of the Citizenship Act, central government hereby makes the following order, namely, the order may be called Sikkim Citizenship Order 75. Then every person who immediately before 26th day of April 1975 was a Sikkim subject under the Sikkim subjects regulation shall be deemed to have become a citizen of India. Now, my lord, in 1975, persons whose names were entered in the register of Sikkim subjects were deemed to be citizen of India. So if their names were entered in the Sikkim subjects regulation, they were citizens of India. Otherwise, every non-Sikkimese who is an Indian is a natural Indian citizen. There is no question of persona non grata. My lord, there is a historical background for promulgating this 1961 regulation in 1961 by Chogyal. The reason is not redundant. A small state, which is still today the least populated state of India, by courtesy God, my lord. It is still covered by most of vegetation, and the best vegetated state in India is the green state of India, my lord, till date, was facing immigration from all sides. So to save the identity of the original Sikkimese people, who consisted in those days of three major, my lord, whatever we call them, tribes or whatever, were saved. Bhutia, Lepcha, Nepali, they were saved. People who started, my lord, migrating in the name of Bhutia from Bhutan, from China, from this part of India, which is predominantly Nepalese origin, that part of Sikkim, which is Nepal, my lord, this law had to be promulgated so that here and no more policy is adopted by Chogyal. And persons who were, my lord, by the dint of that regulation, filtered by way of this filtration process of the regulation, were entered as the original Sikkim subjects in the Sikkim register. And after merger of Sikkim, automatically by dint of this citizenship amended order, all the original Sikkim subjects became Sikkim nation, my lord, Indian nationals. So there is the question of anyone who is either an Indian or a Sikkimese on that day, or their descendants becoming persona non grata. If you're a subject of Nepal, you're a subject of Bhutan, migrating after that, you have to face the natural consequences, which is available for the rest of India, my lord. It's not a special law of Sikkim. Now, my lord, that is the ramification. Now, my lord, I'll go back to the original stream. That's why I told my lord, I'll go a little slower. There's so many hills and dales, and most of it uncharted route, at least for me, my lord. My lord, page 188. This is again Sikkim Gazette notification, my lord. Notification dated 20th of March, 1989.
188.
My lord, 89. It is my lord, page 188. Yes. My lord, it is Sikkim Gazette notification extraordinary dated 3rd of April, 1989, which notifies a Government of India notification of 20th of March, 1989. This is the Government of India notification. SO 214E, in exercise of the powers conferred under Section 7 of the Citizenship Act, hereby makes the following order to amend the Citizenship Order of 1975, my lord. Lordship remembers page 178. This is the amendment. This order we call the Sikkim Citizenship Order 89. The Sikkim Citizenship Order 1975, page 178. To paragraph 2, the following proviso shall be inserted. The provided that any person whose name was eligible to be entered in the register maintained under the regulation, but was not so entered because of any genuine omission, shall be deemed to have become citizen of India on the date, if so determined by the central government. How the central government determines? My lord, next page. Central government orders a special committee. Page 189. This is also same day, 3rd of April. The central government hereby constitutes a citizenship committee to look into the case of genuine omissions of Citizenship Amendment Order 1989. These are the people, my lord. My lord, for government of Sikkim, my lord, kindly see what was the magnanimity of this post. Government of Sikkim, item number 2. The committee is authorized to invite application, my lord, 3rd column. The committee is authorized to invite application as per the provision of Sikkim Citizenship Subject Amendment Order 89 to scrutinize the said application and conduct inquiry as may be necessary to determine the eligibility of the applicant as per the guideline annexed. The committee may co-opt officials, experts. Then application shall be received within the period as may be specified. District collector shall scrutinize initially, my lord. The committee, upon being satisfied, shall recommend the names of such applicants as are considered genuine omissions in terms of Sikkim Citizenship Amendment Order 89 to the Government of India to issue necessary orders. My lord, this is the committee which will make a list of genuine omissions and recommend to the central government. My lord, under this, lordship may kindly come to next page also, 190 D. Persons holding regular government job before 26th April 1975, provided that the appointments had been made under the exception clause pertaining to non-subjects and his natural descendants. Lordship will kindly note this exception clause comes out of regulation 4.4. We'll come to the regulation later on because, my lord, I've broadly tried to divide the subjects between citizenship, Sikkimese, non-Sikkimese, and, my lord, employment. So employment is the core issue. It is not that they didn't want employment and they wanted a driving license. That's why they have come. This is a generalized, my lord, stand taken today, dehorse plain. Not the issue. Issue is by code, employment, my lord. Everything generalized out of that, my lord. 1614 without, my lord, 1619 is, my lord, in the absence of these, Article 14 is almost void. Article 21 can stand on its own feet, my lord, even minus Article 14. But Article 19 and 16 are void, my lord, if Article 14 goes away. And Article 14 is meaningless if Article 16 and 19 are not in play. My lord, 190.
What do you have to say about Article 16(1) in the context of your argument?
My lord, these are tested by Article 14 again.
So 16 is not controlled by Article.
My lord, Article 16, the entire up till 4A are not independent clauses as has been held, my lord, probably post-Sabharwal. These are not independent clauses. We read them, my lord, together. First, the equality clause, then the non-obstante. The equality clauses are, equality clause is not independent of the non-obstante clauses. That's how the lordships have told us to read it, my lord. That's how, my lord, Sabharwal and post-Sabharwal.
Right, but if we have understood correctly, you are saying that all that this regulation or this procedure implemented by the state of Sikkim will be that they will be citizens of India, but they may not be entitled to employment.
May
That
not
your
be.
argument?
If they don't come within that clause.
So that's why we are asking, how do you apply Article 16(1) to the facts of this case and save this?
371. In the presence of Article 16(1), 371 FK was brought in.
But then 371 does not have any overriding effect on Article 14 and 16. It is always subject to scrutiny of its constitutionality.
And it was scrutinized, my lord. It was scrutinized. This exception clause was scrutinized by the Supreme Court. That's how Surendra Prasad comes in. It's not because of anything that everyone relies on Surendra Prasad. As my friend, Mr. Chaudhary, oh, they are now coming out with. Article 371 virus was challenged in Kaji Lenduk Dorji, upheld. Lordship remembers. This particular clause 4.4, this exception clause, which apparently offends my lord, Article 16 and 14.
Just, which is that clause 4.4?
My lord, my lord,
Would like
my
to
lord,
go
kindly
to
come to page 141.
141.
Yes. I originally thought, my lord, I'll address your lordship to that part of the fact in, my lord, that employment subject, but still, yes, yes.
141.
141, 141.
Some problem with
141.
the pagination of this convenience compilation.
No, volume A, the same volume, my lord.
In fact,
Volume A,
After 116, 174.
116, it directly comes to 174.
no, man, there's something wrong, I think.
It's a-
Volume.
After 116, directly 174.
My lord, in that case, probably instead of the bound volume, I have to take your lordship to the original retapil. Retapil is, my lord. No. My lord, this, yes, my lord, this volume is not correct. These are later editions, my lord, by courtesy one of my learned friend. No, my lord, I'm scanned, sorry. My lord,
141.
my lord, volume A, my lord, probably your lordships have to go back to the original judicial file,
Yes.
which contains the writ appeal. And incidentally, my bound volume is, I'm sorry. No, my bound volume was directly from my pleading. My lord, I'm awfully sorry, my lord.
Okay.
My lord, writ appeal, if your lordship kindly comes to page 140, is it there?
140.
140 and 141. Writ appeal,
Yeah,
it's there, my lord.
140, yes.
140 and then 141.
Yeah, 141.
Yes, top.
Appointment.
At the top, 4, appointment. Well, this 4 is actually a part of clause 4 and this subclause 4. That's how it is actually referred to as 4.4. Previous page, my lord, 41, 42, 43, and this is, it should have been 4.4, but it's independently termed as 4. It is not an independent clause, it is 4.4. Can I read it, my lord? Appointment, this is the clause. Appointment to service under the government shall be by one or both of the method indicated below. Direct recruitment, promotion from one grade to the other. Direct recruitment shall include appointment on contract and appointment on deputation. Now, provided these two types of appointment shall be made having due regard to the exact nature of specific duties and responsibilities and the qualification required for the post, and further provided that 1, non-Sikkimese national may be appointed only when suitably qualified and experienced Sikkimese nationals are not available. And number two, replacement of such appointees by suitable Sikkimese candidates may be made as and when available. Mutually agreed terms, provided that these two, both direct recruitment and promotion appointments shall be made having due regard to the exact nature of the specific duties and responsibilities and the qualification required for the post, and further provided that one, non-Sikkimese nationals may be appointed only when suitably qualified and experienced Sikkimese nationals are not available.
So this is under challenge in the writ
This
petition.
was under challenge before Supreme Court, and Supreme Court has upheld it.
And then in the writ petition, this is also, this was challenged again.
No, my lord, there's no question of again challenging this petition because this clause was already upheld in way back in, my lord, 1994 by the Honorable Supreme Court. Surendra Prasad, my lord. I'll cite that. I'll cite. This was already, my lord, challenged, and under the touchstone of Article 371 FK,
Is the judgment?
my lord, 1994 Supreme Court, AIR 1994 Supreme Court, page 2342. My lord, the bunch of the judgments are there. How does it look like? My lord, if it is not there, my lord, I've got copies of the judgment. Here, of course, the SCC is, my lord. Nine, Enuka, there's a bunch of it.
Supply is the copy.
My lord, we have.
In this compilation, it is there?
No, in another compilation it is. No, my lordship need not take it. My lord, we have. I only wish, my lord. My lord, your lordship will excuse the small markings.
Fine, fine.
My lord, I'm sorry for this. My lord, the first case in this compilation is Surendra Prasad, starts at page 1, my lord.
One more, yeah.
Division bench judgment of my lord Justice Amedi and Venkat Chalaman. My lord, just cut it short to the specific issues. My lord,
Just a minute.
my lord, my lord. Starts at page 5 bottom. Page 5 bottom. Page 6 of the SCC.
तो देखो इसमें नहीं पता है कौन पता है it starts from 350. Question answer दी किया है, इसे तो लगे हाँ? लगे बोलते थे हाँ पूरा जी रिप्लाई बोलेंगे तो आराम से जा अपना तू रिप्लाई बोलेंगे तू रिप्लाई बोलेंगे मत बोलो हঠাৎ ये रिफ्रेश मैक्सिमम
My lord, in Surendra Prasad, my lord, their lordships boil down to three words of the Constitution. The non-obstante clause in 371. Notwithstanding anything contained in the Constitution, that saves everything. That was, my lord, if I can understand correctly, page,
Para 20.
yes, my lord, page 20 also, the last line of para 17, just above para 18. It is therefore obvious that the learned judge in High Court missed the real objective of qualifying all clauses of Article 371F, which with the omnibus, notwithstanding anything in this Constitution. My lord, the best part for us is it answers almost everything. Like that is a Chogyal time regulation. That it was subsequently adopted by the state of Sikkim within India as a statute under Proviso 2 309. And as of date, it's a statute under 309. That the president had power to amend it within 2 years, and it was not amended. In 1994, Supreme Court holds it was not amended and is still in force. And it upholds clause 4.4 specifically. And Lordship will see
Has the learned single dealt with this judgment?
indirectly. Yes, it is referred and relied. And my lord, I will, with all the humility at my disposal, I'll say, which could not have been done directly has been sought to be done indirectly in this judgment. That's how it is bad in law.
Okay. Go through the single judge's judgment now.
My lord,
Place the judgment of the single judge, learned single judge.
my lord, yes.
At 2,
Active.
continue.
My lord.
My lord, can I take little leave of your lordship's matter? I have spoken to my learned friend. He says he will require the rest of the day. My lord, I'll give my reply on another day. I'm going to Delhi, my lord, for a matter tomorrow. I thought, my lord, today it will be my turn. He will reply. That is how I walk. It's scheduled, my lord. I can reply on Monday, my lord.
There are pastures greener also. That's why. Monday. Ay. I'm gonna put it. more जाएगा.
Not a problem.
Monday will be too dicey for me. My
Yeah,
Monday will be too dicey for me. My lord.
no, not Monday. We'll fix it on a date because now, since from this next month, we may not have this combination. So we have to form a special bench.
Yes, yes. On next day, we can conclude, my lord.
Yeah,
On next day,
Yeah,
if my learned friend carries for the, it takes about 1 hour more. I'll take about 1 hour.
I think so. I think so. I'll agree on this.
2 hours, I think 1/2 we can
we'll
conclude.
fix a date, we'll consult and then. we'll
And
fix it
my
on
lord,
any other day.
both of us agree on one point, that this is one case which has really taken both of us to uncharted routes. And both of us, we walked slow.
Lord, on one occasion, lordships indicated whether you have filed any written argument. I have filed, we have filed, my lord.
Yeah,
My-
that is.
Both the
Yes.
parties.
And
Both of
regarding
us.
Surendra Prasad Sharma's case in page 11 of my written argument, I have dealt with.
We'll see.
Yes.
We'll go through the judgment and we'll find.
My lord.
That's true.
My lord.
189, yeah.
My lord.
Yes.
No, my lord, Lordships have seen page 189 read with page 190 clause D.
Persons holding
Regular government job on before so and so, provided that the appointment has not been made under the exception clause pertaining to non-subjects and his natural descendants. So, my lord, this has got
Now,
some.
earlier it was 31st of December 1969, it was extended up to 75.
My lord, coming of the force of the Citizenship Act now. Now, under this, my lord, your lordships can just make a note that under this process, by this notification scrutiny process, altogether 40,083 citizens were recorded in the Sikkim register of Sikkimese or subjects.
And with another indulgence,
Yes,
around 30,000 more.
33,348
So total 73,431, but
obliged, my lord. That's the exact number. And the references are page 192 and 193.
yes,
Yes.
reference to
192, my lord, it speaks of that, the further number 33,348.
Yes.
Then, my lord, that ultimate 193 speaks of the ultimate figure 73,431.
yes, yes.
I'm told, my lord, after this also, a few hundreds probably were added.
Okay.
But anyway, for us, it is sufficient. None of these petitioners fall within the ambit of this. It's a clear case. None of the petitioners claim that they fall under this.
Their names are not included in the register.
Obliged, my lord. Obliged. My lord, this is the position as regards Sikkimese, non-Sikkimese. Not citizen, non-citizen. There is no concept of non-citizen in this country, my lord. Even a foreigner becomes a citizen. Now, everyone is an Indian national. But within that Indian national broad periphery, there is yet another circumscribed circle of Sikkimese, non-Sikkimese. We are concerned with the rights of Sikkimese, non-Sikkimese. Honorable Supreme Court have coined a new term, local, non-local, in Surendra Prasad. All the same. Sikkimese, local, non-Sikkimese, non-local. Now, my lord, keeping this in mind, now we see the scheme of employment. Lordship may, because the notifications under this employment scheme are under challenge and interfered by the Honorable Single Bench. My lord, the story starts at the rules of 1974 again, page 136. Now, my lord, actually, this printing is post-independence, when this was treated to be rule under 309. Now, what we are reading today is a part of the 309 regulation. Sikkim Government Establishment Rules 1974. Lordships have already seen, my lord, 4.4 at page 141 thereof. In exercise of the powers conferred under Article 309 of the Constitution of India, Government of Sikkim is pleased to adopt the Sikkim Government Establishment Rules 1974 as the rules regarding recruitment of so and so, with modifications set out here in below with effect from 26/4/1975. My lord, may kindly skip and for a ready reference again, my lord. Page 141, is that 4.4? Page 1.1, 141, is that? Clause 4.4, which your lordships have seen, my lord. In the proviso itself, it speaks of non-Sikkimese national and Sikkimese candidates, where stated preference have been charted out for Sikkimese national, and how Sikkimese national will get precedence over non-Sikkimese national. My lord, kindly now come to page 185. My lord, may kindly come to page 185A. Next page. There's a typograph. I think there's a better part, my lord. 185A. This is the basic document, my lord, after merger. This is 25th of September 1976. In order to ascertain the residential qualification of candidates who claim themselves to be locals, at the time of seeking employment, it has been decided that candidates should be asked to mention whether their parents' name have been recorded on or before 15/5/1975 in the relevant government register. My lord, now we know what does this relevant government register means. It is that updated, my lord.
1961.
My lord, my lord, my lord, my lord. Now, why it is important, my lord? The root is this, which is never under challenge. This notification and its subsequent modifications are meant to regulate only and only employment field, nothing else. My lord, just for a daily reference, which was spelled out, my lord, although out of pleading out of context, that taking chance of this, they're not being given even the
Driving license.
driving license. My lord, I've just got the instruction by, my lord, driving license all over India is given or non-given, regulated by your motor vehicle rules and the Motor Vehicle Act and the rules framed thereunder. And as of date, the entire regime has been computerized, my lord, by a digital program known Sarathi. One is to apply in that portal, whether he's in Sikkim or in Andamans. There, COI is not a
Prerequisite. It is
it's,
prerequisite.
it is not a prerequisite, my lord. I've got it in instruction. It is not, and then, my lord, the portal is an all India portal. It is regulated by an All India Act and rules framed thereunder. There is no special, my lord, mention of anything else than what is mentioned under the Motor Vehicle Acts and the rules. Anyway, these are not parts of the pleadings. That's why, my lord, argument and counter argument on air will be. That's not the issue here. The issue is employment. Now, my lord, 185, from 185A, my lord, we move to 186. It is hereby, my lord, 186 middle. It's a notification number 285G dated 28th of January 1980. Thus you got, my lord, in the left-hand column, middle. First column, middle, at page 186. It is hereby notified for information of all the head of the departments that domicile residential certificate issued by sources other than district collector shall not be accepted as valid. This is in continuation of the my lord, department notification dated 25/9/1976. Lordships have already perused that. My lord, next page. In continuation, my lord, of this subject, this 9th April 1981 notification is issued. In modification of the department memorandum dated 25/9/76, your lordships have already seen it in, my lord, page 185A. And notification dated 28/1/1980 at page 186, just before. Governor has been pleased to authorize the district collectors within the their respective district to issue certificates to persons, identifying them in the following groups to enable them to apply for employment in the state. Well, this is nothing new. Whatever started in 1976, it's just a continuation of that. It is a government policy which is permanent in nature. There is no change in the government policy. It's coherent in all respect. A person whose name is found recorded in old Sikkim register prior to 1975. speaks of local, non-local, a law which is upheld by Supreme Court. A person whose name is not found registered in the old Sikkim register subject, but she has established beyond doubt that the name of his, her father, husband, paternal grandfather, brother from the same father has been recorded in the old Sikkim subject register. Then the person who has agricultural land, rural areas has been ordinarily residing in the state of Sikkim. My lord, nothing but the reiteration of those tenets which entitled someone to get registered under the old Sikkimese register. Nothing but reiteration of all those tenets, nothing new here. A person whose father, husband has been in service of the state government on or before 31st December 1969. Father, husband, their wife, children. This is also not under challenge. My lord, two things flow. 1976, the notification speaks of employment purpose only. These are notifications, local, non-local, for the purpose of employment only, and nothing else. It doesn't regulate anything else. Next, it is, my lord, reiterated in 1989 that to apply for employment in the state. And then, my lord, for the first time again, these four qualifications which are there since 1961 have been reiterated and rewritten only. My lord, kindly come to page 195.
November.
My lord,
22nd
yes. 22nd November 1995. This is under challenge and interfered by the Honorable Single Bench. My lord, kindly see, this is not a new notification. This is in continuation of the earlier notifications of 1976-81. Some cut tailoring here and there. In supersession of the memorandum dated 25th September 76, notification dated 28th January 80, and memorandum dated 9th April 1915, and circular dated 17 March, it is not there. The state government is hereby pleased to authorize the district collectors, subdivisional officers, and revenue officers within their respective jurisdiction. My lord, here is a digression. Previously, it was confined to only district collector within his district. Now the power devolves to district collector, SDO, and revenue officers within the respective jurisdiction to issue certificate of identification to the persons falling in the various categories indicated below on the recommendation of the Gaon Panchayat. Now, this is also not interfered with. And being duly satisfied with such recommendation, a person whose name is found recorded in old Sikkim register, well, this is not interfered with. A person whose name is not found registered in the old Sikkim register, but he or she has established beyond doubt that his or father so-and-so, brother from the same father has been recorded in old Sikkim subject register. This is also a repetition of the same. A person who has or had agricultural land has been ordinarily residing, same, my lord, flows from 1961, reiterated. A person who is holder of Indian citizenship certificate issued by the district collector, Government of Sikkim under the Sikkim Citizenship Order 1975, as amended White Sikkim Citizenship Order 1989. This is added. My lord, these goes to the advantage of people who, numbering around 73,000 and odd, were added. It doesn't curtail anyone's right. Then, a person whose father, husband has been Sikkim government service on or before 69, certificate of identification shall be valid for purpose of employment only. Now, my lord, this employment only business has started from 76. There is no change. 81 reiterated. My lord, it's reiterated in 1995. Two questions flow from here. One, 1995 order especially the part you are challenging, is a fallout of 1976 order, reiterated by 2 other notifications. Never given up. It's a part of the process, my lord. The original notification being not under challenge. Can you pick up one now? Number 1. Second, 1995 notification is challenged after, my lord, several decades. Any rational reason given to satisfy the court.
Third petition was filed in which year?
My lord. 16? 2016. 21 years. 21 years, 2 decades, my lord. After 21 years of the cause of action having, my lord, the cause of action, if at all, had arisen in 1976. In 1976, if they have inherited this, nothing, my lord, the writ petition and the order passed therein is liable to be interfered with on this count first, if not alone. Unexplained delay, number 1. Second, the cause of action, the original part thereof is not under challenge before this honorable court. Now, my lord, from this, kindly travel to page 197.
107.
197. 27th of September 1996. This is also referred to in Honorable Single Judge's order, my lord. 197. Lordship Court. Is a notification dated 27th of September 1996. In partial modification of number so-and-so dated 22nd of November 1995, Lordships have just been pleased to peruse that. The state government hereby makes the following amendments with immediate effect. In the said notification for the words subdivisional officers, revenue officers, wherever they occur, the words additional district collector shall be substituted. Nothing here, no there. Paragraph 1, after the words with such recommendations, the word after proper police verification shall be added. Lordship remembers, my lord, it was to be verified by Ga Panchayat and these officials. So a police verification is also added. For item number 5, the following shall be substituted. A person whose father husband had been in Sikkim government subject on or before so-and-so, 69. My lord, this is same. And permanently settled in Sikkim after his retirement. This is added. This is not under challenge. Certificate of identification obtained by such person shall be for the purpose of employment only and no other purpose. My lord, when it is written that employment only, I will humbly say, my lord, that and for no other purpose is redundant, is for only for our poor knowledge of English, that these have to be reiterated.
This is where the shoe pinches.
My lord.
This one.
Yes.
75, 90.
My lord, it started, your lordship.
This one.
Educational, we have to get. Citizens are correct. They will have all rights of. Yeah. This is our class. मैं going में कह रहा हूँ people coming and they are otherwise citizens. They are otherwise तो बाकी फिर इसके कारण इनका क्या घट रहा है? They cannot be stopped from anything. Yeah, 76 was 76 में जब इसको repeal करते हैं now very carefully. Like समझा what do you think? इनको आज के तरह किस चीज से कौन होता है? For the purpose of Where is the shoe pinching, Mr. Dev? Please come straight to the point.
My lord, for me, government, it doesn't pinch anywhere. It
No.
pinches at the,
Percent.
for them, they say at this employment only and for no other purpose, subject to correction.
No, what they are saying that these other 4 classes of persons which they have mentioned, they are claiming parity with these 4 category of persons. They are claiming parity with those persons.
क्या है क्यों? नहीं यार.
No.
Then
The 1, 2, 3, 4, these 5 categories are there in 1995 order, na, sir?
Yes,
Notification.
yes.
There are 5 category of persons.
Hmm.
These 5 category of persons, they are claiming, the 5th category is claiming parity with the 1, 2, 3, 4. That there
They-
is no restriction that their certificate of identification would be confined only for the employment purposes. And therefore, their rights have been, which has been curtailed, and it has been mentioned that it is only for the employment purpose and no other purpose. They are agreed by this condition only.
Yes. Now kindly see the fallout.
Yes.
My lord, a state is not an employment seeker that is on the deprivation part. If he takes, I am deprived. No, I am on the governance part. Kindly see the fallout. I'll go into little deeper aspect, my lord. Here I will share a podium with your lordship.
Just a minute, just a
कैसे कर रहा है वो तो मैं कह रहा हूँ कि मान लीजिए मेरा ये अप्लाइज टू it's an identifying card. It's an identifying card. Identification of the action. So everywhere, it's a photo. मैं बता रहा हूँ
It will report page, one page. This one, page 679. Baba ji request. 202. यार 202. 203. Key hole 2. Wait. 1, 2, 3, 4, 5. Even commentary is there, not 6, 7. I don't read personally.
only for education. क्या वो कैसा क्या एजुकेशनल नहीं हो सकता तो कुछ मतलब ये है कि प्रॉपर्टी डील में भी चाहिए तो अलग बात पर जो सिटीजन्स का राइट है वो तो कटल नहीं कर सकते हैं लोग व्हाट इज द इशू हो सकता है कि दिस इज ओनली फॉर ठीक है बड़े दिनों में नहीं यू हैव टू मेक इट फॉर अनदर पर्पस कैसे करते दैट्स व्हाट आई एम इमोशनल लाइन उसमें जाके कुछ निकल let us peep into the judgment of the, we have not understood what was the grievance of the.
My lord, my lord, let me tell. 1, 2, 3, 4, they are not agreed because they do not come anywhere within that. Of page 195.
Yeah.
1, 2, 3, 4 is not under challenge, not interfered by the honorable court.
Challenge भी नहीं था.
5.
That was not challenge.
That was not challenged, which means they are not, my lord, they cannot in any view of the manner fall within 1, 2, 3, 4. The original Sikkim is. They come
with 5.
5. 5, what they say, don't restrict it to father, husband. We are the grandchildren. First line.
One grievance is this.
One grievance is this. Number 2, we are the sons and wives also. 16 to so and so. But why for employment purpose only? Now, my lord, kindly see the futility of this argument when it comes to your lordship deciding the issue on for me the state to administer it. This is a zone carved out for a particular purpose. We are limiting the zone of consideration for employment. Yes, my lord. We are limiting the zone of consideration for what? Employment. And the carving out zone purpose is limited for employment only. We are not extending to any other region.
That's permissible.
That's permissible. Now, suppose, my lord, this carving out zone is to be now extended. My lord, The order of the court says it will not be read to be restricted to employment only. What does it mean? These 4, 5 restrictions will now apply for everything which they are crying out now. If we really impose this, that all these restrictions will not be for employment, for the purpose of their license also, which it is not. What it comes to. Now, if I want to interpret Honorable Single Judge's order.
No, that we agree with you. But at the same time, as citizens of India, you cannot restrict their rights, whatever rights are available under the statute or the Constitution of India.
My lord.
That you cannot restrict.
My lord. So long 4.4 exists, we have to make regulations by your legislation of executive order to define, my lord, who is a Sikkimese, who is a non-Sikkimese by a rational process. That's what we are doing. If 4.4 remains, my lord, to effectuate that 4.4 rationally, there must be 2 zones, local, non-local, as Honorable Supreme Court puts it. The statute uses the word Sikkimese, non-Sikkimese. There must be a way to find it out.
Local, non-local will depend on whose name is there in the register.
Obvious, my lord.
All right.
And it starts from
What
19.
about the children who were born later?
My lord.
What about the children, the grandchildren who were born later?
Because, my lord, the tenet of 1961 remains. The tenet of 1961 restricts to wife and child. Major or minor, my lord, let us give up major minor part after it is. Now, Sikkim registrar was made with that tenet of wife up to wife and 1969 employee, their wives and children.
Correct. But what about the descendants?
No, it stops at that, rightly or wrongly.
Then it will offend the provisions of citizenship.
It won't. It won't. I'm telling my lord. It won't, because even after the Chogyal regulation was given a go by, the registrar which was made in pursuance of that remained as the base. And with that base, further 70,000 and odd were added with this qualification. 69 and their
So what
descendants.
is the statutory sanctity of the register?
My lord.
What is the sanctity of this register?
371A, 371FK. All laws of that period of time are, my lord, valid laws, notwithstanding anything contained in
The 61 regulation is the law you're talking about. That has been repealed.
It is repealed.
Then it can't be, it cannot remain in.
But my lord, the Citizenship Amendment Act itself says the register maintained under that will be the base.
Mr. D.
Which is not under challenge.
Please,
my lord.
Please understand what we are trying to ask you. Maybe we are not clear. Maybe we have not been able to understand.
My lord.
See, the point is, let us go on a purely technical point here. You are saying 4.4, for whatever it means, it is now established and upheld by the Supreme Court. So that nobody can question. 4.4 allows the government to make a distinction between locals and non-locals or Sikkim subjects and no, whatever. So if it comes to it, you can treat these 2 categories differently in whatever is written down, you can do it. Whether that is discriminatory or not, unfortunately, we can't examine it now. Beyond that, we cannot say anything. Although maybe there was, but anyway, the other part is, it all started with the regulation of 1961, right? That was treated as a law of the post-accession period. Post-accession.
And repeal.
Correct. Now, this 1961 regulation was repealed. Correct. 371F deals with those laws which were in force before accession of Sikkim. But it would mean that those were not repealed. Repealed law cannot be treated as law.
Right.
Yes.
Absolutely.
So, the law which has been repealed is the law or regulation which deals with the register. Today, after 1975, what is the sanctity of this register?
I'm obliged.
Who maintains it? Give us that.
My lord. The clear-cut answer is the Citizenship Amendment Order. Lordship, kindly, let me just verify the page number, then I'll trouble. Yes, we have to go a little back. My lords,
Which is the law, which are the rules
yes, my lord.
which comes into play while maintaining these registers, making entries? Is it just a notebook where somebody writes down somebody's name, or,
Good.
for example, in
I'm
NRC?
obliged. Well, it's a pinpoint
NRC,
query.
the Register General of India maintains it. There are elaborate procedures, there are regulations and
Right,
statutory provisions.
right, ma'am.
Now, what is the statutory provision which is involved in this?
T17.
Who maintains it? How is the entry made? Who verifies it? Supposing there is a claim, genuine claim, that my name has been illegally dropped. What is the parameter on which you go into this? Please throw some light on that.
And I can start. 61 regulation had a rule.
Hmm.
Lorships have gone through that. Both the regulation and the rule had appellate provisions, which are now repealed. Now, why they are repealed? They are not repealed
That
because
we
they are
agree that after this regulation was repealed, it will not enjoy the protection of Article 371F. That you agree.
kindly see the legal fiction here. That's what my lord, again, I very briefly address your lordship on that. Maybe we have to see why was it repealed? Because in a land under Constitution of India, you can't have two parallel laws on citizenship. One Sikkimese law, another Indian law. That's why it was repealed, and the void was filled up by page 188. Page 188.
Yes.
My lord, in exercise of the powers conferred under section 7, the central government hereby makes orders following to amend the Sikkim Citizenship Order 1975. My lord, Sikkim Citizenship Order is in 178.
Exactly what I'm asking. Name not.
My lord,
he also becomes.
my lord, now this is to amend page 178. This is the basic document of citizenship post Indian Constitution coming to force in this part of India. Kindly come to page 178. We have to start answering this question, my lord, from page 178. My lord, 75 only adaptation laws, first schedule repealed. Lordship remembers. 75 itself, June 1975, this notification comes in force, filling up the void. Government of India Ministry of Home Affairs, notification dated 16th of May 1975, published on general information. In pursuance of the notification, Government of India Ministry so and so, so and so, central government hereby appoints 16th May 1975 as the appointed day for coming to force of Citizenship Act. Citizenship Act comes to force. Kindly come to the bottom of that page, SO 217. SO 217. In exercise of the powers conferred under section 7, central government hereby makes the following order, namely, the order may be called a Sikkim Citizenship Order 1975. Every person, kindly see my lord, every person who immediately before 26th day of April 1975 was a Sikkim subject under the Sikkim Subject Regulation 1961, after repealing Government of India says so, shall be deemed to have become the citizen of India on that day.
Oh, that is not on the continuity of the regulation.
It is, my lord.
Status under the repealed.
Yes. Now, how I get a status? By dint of being son or wife of a government servant prior to 1969. That's how I enter my name as a Sikkim subject under the Sikkim Subjects Regulation 1961, which continues as the base document.
So after that, the son who was a minor grows up and he gives birth to a son. He doesn't become a Sikkim subject. Is that the position?
Yes, that is the position. My lord, When it comes to Indian citizen, this is a different question. But by law, my lord, by law, Government of India says that Sikkim will remain Sikkim as it was.
Maybe, but citizenship is a list one subject.
No, it is not citizenship.
List one subject.
It is not citizenship. It is not citizenship. It is local, non-local. Even a non-local is a citizen of India. The question is, my lord, we will not interpolate each one. My lord, citizenship is not under question.
The constitutionally recognized concept, local and non-local.
Yes,
Which
my lord, 371F. If the law has been made and law is continued, it is set under 371F. This is the law, and my lord, we don't need 371F. By citizenship amendment order, Government of India itself says, for the purpose of determination of this group of people, we will maintain and update the Sikkim register. And Sikkim register is one which is made under that regulation of 1961. Although repealed, the ethos continues, not beyond the purpose of this, not beyond the purpose of local, non-local. In
Wait for.
जो मार्कर जो भी that's exactly. डबल कराना है एक साइड तो डबल कराना हर नोट तो कल मुंह ऐसे बोल दिया all the impact maybe even that without मोटा मोटा मुझे जो इनके लिए बोला है कि not connected to this, not connected with it. Example. देखो सदन पुणे आता है और वो उनको जिनके नहीं
So, Mr. Deb,
My lord.
before the petitioners, their previous generations, they are not subjected to this clause. Only from third generation onward it comes.
Because, my lord, from 1961, Lordship has seen, it was limited to son and wife. Not children and wife yet. Children and wife. My lord, it was never under challenge. And there is a reason, my lord, for not challenging it. I will come to that also a little later.
There is a reason
When-
for?
My lord, the government of India, when they wanted to supplement the Sikkimese law of nationality with the Indian law of citizenship, they must have a reasonable base, my lord, for starting that exercise. They have found, the government of India found the Sikkim register to be the reasonable basis. How was the Sikkim register made? It was made under the regulation of 1961 with this 1, 2, 3, 4. Remarkably, amongst them, son, children and wife, limited to children and wife of people who were up till 31/12/1969 as the, my lord, Sikkimese employee. And my lord, whether it is permissible or not, my lord, we have to go to the root of the power being exercised. Citizenship Act. My lord, I told my lord, this is an uncharted route for me. It's so interesting. And Citizenship Act, my lord, allows different types of citizens, different denominations, different qualifications to be, my lord, imposed for acquiring citizen of this.
This is not acquiring citizen. Their forefathers have been treated as citizens. Sikkim subject. Suddenly you say that, sorry.
No, no, no,
you will
no.
be downgraded.
No, my lord. For the first time, the Sikkim subject concept being codified came from 1961. And Government of India says the instrument made under 1961 will be my base instrument.
That may be a basis for that purpose, but that can't be the, once it is repealed for all purposes.
No, my lord. This citizenship order has been made under Section 7. Kindly have a look at the Section 7 of the citizenship. Neither the Citizenship Act nor these, my lord, exercises and citizenship orders are under challenge in any manner. And my lord, I will also take your lordship to the Honorable Single Judge's order. I told my lord, it's a well-written judgment with all humility. It is not a well-reasoned judgment. There is no reason at all. But for my lord, giving a commentary of facts, your lordship will not find any reason. My lord. Section 7 of the Citizenship Act, 1955, as it stands amended today. 7.
Citizenship by incorporation of territory.
Yes. Yes.
If any territory.
Any
becomes-
territory becomes a part of India, the government, central government may, by order, notified in official gazette, specify the persons who shall be citizens of India. Specify the persons, my lord, by reasons of their connection with that territory. And those persons shall be citizen of India as from the date to be specified in that order. Now, my lord.
They specify that those persons whose name were in the register Sikkim register would be treated as citizen of
Oh,
India.
my lord, how can the government of India make two planks out of the same register? This register is made out of people who were within son and wife periphery of 1969. How could government of India change it and make another class hitherto unknown in law? They have to specify by way of a law,
Which is that
otherwise
another-
government of India,
Which is that another class?
my lord.
Which is that another class?
The another class is son and beyond son and daughter. Beyond son and daughter who are not included in this Sikkim subjects regulation register.
Then
This
you
is a
need
new
to
class?
say that
My lord,
it's
this is a new class, my lord. Kindly see.
Sir,
Specify
we
persons.
fail to understand, sir.
My lord, kindly see.
Your 61 register says, this 61 regulation says,
Limited to
was
wife
born
and
in the territory of Sikkim and resided therein. One of the category
when?
who
When?
1961
Yes.
was born in the territory of Sikkim and is resident therein.
They don't claim that
He
they
is
are.
entitled, he is entitled to be part of this Sikkim register.
Yes. They don't claim under this.
And suppose after this 1961, some issue is born to a person who was born in the Sikkim territory, he can't be treated as a citizen
Yes,
of
he
Sikkim.
will be. And he,
Can't be. How can it be? He was not born in the Sikkim.
no, my lord. If the law doesn't say so. We are not restricted.
What you have said.
No, I am not telling. My lord, I'm sorry. It is they who are telling that clause 5 is bad. My lord, kindly see what is challenged.
Mr. Day, what my lord, the Honorable Chief Justice
My lord,
has
my lord, my lord.
just inquired, let me put it in a slightly different manner. See, now, so far we have heard you, whatever little, and we understand that the issue boils down to one point. There was a transition, there was merger, there is a historical background. We have seen that. We have seen that. Now, here there is a class of Sikkim subject who were in government service prior to 31st of December 1969. That is prior to the merger. By the regulation of 1961, these people, their wife and minor son, minor children, whose names are in the register, they have been treated as Sikkim subject.
Not treated. They were subject to verification included in the
Alright,
register.
Subject
There
to
was a
verification is on facts, but
And if they apply,
all right, so they would be eligible to be treated as for citizenship and all other purposes like other categories of Sikkim subject. Let's put it in a broad parameter like this. Now, they get it, thereafter they become Indian citizens. Now, you are saying that the father is okay, mother is okay, minor child is okay. But since 1975, several years have gone. So these people have grown up, they have their children now. Now you are saying, okay, whatever we had to give, we have given it to your grandfather, your grandmother, your father.
they are the locals.
You can't claim that.
Yes, they are not locals.
Very difficult.
And that clause is not under challenge.
Very difficult. You show us the definition of local in the constitution.
My lord,
Where is the definition of local and non-local in the constitution?
constitution.
Yes.
My lord, Surendra Pratap.
Well,
Surendra Pratap, that's where
in all
the,
respect, we will go by a constitutional definition.
my lord, the lordship say notwithstanding clause saves all these laws. And that's
Because
how,
Article 16.1 and 16.2 does not impel us to accept.
my
this
lord,
notion.
my lord, the question is, can we revisit that subject at all? My humble answer is no.
Which subject?
The subject of local, non-local, as emphasized under the Employment Act. That's why it says for the purpose of employment only.
No, that issue will come when they apply for employment and say supposing they are debarred or denied by taking recourse to 4.4, that will be another subject matter. Here we are only on the question of their status at par with the other category of citizens who are Sikkim subject. Nothing more, nothing less.
My lord, that's not the question here. That's not the question posed by the, my lord, lead petitioners before the lead court. It will be extending the horizon, for which I will need a pleading and I will need a
What is
reply.
the question according to you?
My lord, the question is as plain and simple. Interfere with not 1, 2, 3, 4. Your lordships are telling if 1 was okay, why not the descendants of 1? There is not their question. 2, 3, agricultural land, blah, blah. No. Their question is only limited to 4 and later on, which is renumbered as 5. That, why should you limit it to the sons and, children and wife of 1969 government employees? We are their grandchildren, you come to that also. And secondly, don't limit it for the purpose of employment only. Now, if I don't limit it for the purpose of employment, what does it come to? The local and non-local will go to every sphere. This is not, I repeat, my lord.
We are saying
Just
they are
a
not
moment.
non-locals.
My lord,
You
I-
do it, you do your local, non-local.
my lord,
These people cannot be treated as non-local. That's what
my
we are
lord,
saying.
this is not a question posed before the read code. It is not answered by read code. Kindly see, my lord, whether the read code answered it.
No, Mr. You see.
My lord, we don't have a pleading to that effect.
We understand the complexity of this subject, the passion behind it, both for the state and the other side. But we have.
State is, doesn't have a
Just
question,
a
my lord.
minute. But we have to engage on a very fierce debate on this to bring out the best. Therefore, these queries, we have not made up our mind.
Absolutely,
these queries.
absolutely. We are testing our
See,
size, my lord.
When these people, their father, mother, their brother, they were treated as persons in the service of the government of Sikkim, that original government before merger. Their names were registered in the registered, and they were given the status of citizens or whatever it is. Where is the question of treating their descendants as non-local?
Because, my lord, the register which was made under the regulation, the sanctity of the register itself prohibits. Then you give up that register and amend the citizenship order, which is not under check.
Therefore, we are asking you, if you come to a national register of citizens.
It is not registered, national register, my lord.
Just a minute.
My lord, national
Just a
register is
minute.
altogether different
That
matter.
sanctity of that register is protected by a statute, the NRC Act of 1951. What is the statutory provision which protects this register? We are asking you that.
My lord,
You can't
Citizens-
say it is the repealed act. You can't say
Citizenship Act. Citizenship Act.
that. Where is it? Show us, please show us.
Section 7, order made under Section 7. This is an instrument made under that order. This is an order under Section 7. Under Section 7, all these, everything flows. Kindly see, my lord, section, my lord, probably I made this point. I am obliged to your lordship.
Section 7 of Citizenship Act.
My lord, any territory becomes if this is a special treatment. My lord, this is a special treatment category and special treatment can be given. If not given by law, can be inserted. Section 6A was inserted for us, my lord. Section 7 is already there. If any territory becomes a part of India, the central government may, by order notified in the official gazette, specify. My lord, this is in exclusion of many. Specification. Specify the persons. Specify the persons. It is not that all persons immediately become. Specify that category of persons, my lord, who shall be citizens by reasons of their connection with that territory. Now, the connection with this territory, my lord, by public policy is limited to wife and son if they are not.
Absolutely, absolutely. So, as per section 7, the people whose name were included in the register by virtue of their connection to the territory, after the merger, they will have to be treated as Indian citizens. correct?
Absolutely, yes.
But the people who were born after 1975, how do we expect their names will be included in that register?
No.
They will have to follow the descent.
Yes.
That's the end of the matter. Your
That's not the end of the
argument
matter. There's the.
you have argued straight away in the zone where they want.
Absolutely not, my lord. That's why we are again interpolating into two subjects.
Okay, a person who is born in 1980, how can we expect his name to be there before 1965?
Absolutely, we can't expect.
So
And that's why you were.
that means he will not be a citizen. He will not be a citizen.
My lord, I'm again and again
He is not going to be a
reminding,
Sikkim subject.
my lord, kindly, again and again, I'm reminding, don't interpolate. I use the word interpolate with,
Right, second subject.
no, local, non-local now, there is no Sikkim subject. Local, non-local with citizenship. Even the non-locals are citizens, but they are not entitled to be treated at par when it comes to employment clause 4.4. Employment
Right.
clause,
Now, are you disputing that these people, the petitioners here, their forefathers were actually not included in the register?
I don't know. None of the facts are there before the writ court, which could have been affirmed or denied. Let them show one semblance of document, one semblance of statement. This is a writ petition on air, and my lord, with all humility, decided on air. There is not one reason falling from honorable single judge. My lord, with the best humility at my disposal, I'm telling your lordship, with all responsibility. Narrations of facts up till para 32, 33. Thereafter, on the basis of whatever has fallen supra,
It's only para 38.
my lord, this judgment has to be rewritten. We can't rewrite it. At best, my lord, it can go back to the honorable single judge. At best, he can go back for, my lord, fresh consideration. You give your reasons. My lord, as of date, I don't have a reason to tell, my lord, unreasonable. The entire judgment is unreasonable today. It sends any reason or logic. My lord, whatever has fallen from your lordship, suppose it is there in the judgment, I can have an avenue to argue, either affirm or, my lord, oppose your.
That's all
Yeah,
right,
it is
but
not
these
there.
are all legal issues. So we are putting you.
My
to
lord,
notice.
pertinent legal issues, not only, my lord, the legal issues just falling, pertinent legal issues, my lord, I believe, my lord, there should have been cross appeal. They should have been the first appellant. I can show, my lord, how many things have fallen, which if taken, my lord, I am telling, this is not an adversarial litigation when it comes to government. I have to administer the state. This judgment gives a writ in futility, which no court of 226 or 32 should issue. These are writs issued in futility. You say that these 1, 2, 3, 4 parameters are not limited to employment. These are wide open for all territory. What will happen? That's what is the, my lord, they should have come up, my lord.
That's why we are finding it difficult to understand
is,
what
my
really
lord,
is the grievance.
my lord.
But there is an issue.
Definitely.
They may not have been able to make out
My
a
lord,
case
not
on
only
that
that.
line, but there is a grievance.
My lord, there is an issue of very pivotal nature. It is another matter. It is not, my lord, addressed in the proper way.
You see,
My lord, whatever has fallen from your lordship, even if
I
this is
find
there.
this subject very interesting, and
True.
more so when you are the leading counsel for
My
the.
lord, my lord, my
It's
lord.
always a pleasure to listen.
My lord,
to,
there can be
eminent
any more
counsel
better
like Mr.
commendation for me.
Therefore, it is very alluring to get engaged.
My lord,
in a debate.
I'm a blessed man.
You see, forget everything else. Look at the legal spectrum in front. Citizenship laws in entire world, including India, it recognizes citizenship at the first point. That is either the point where you acquire citizenship, which could be by birth, by naturalization, and which is by descent. Correct. So once Mr. X's forefather has been found to be an Indian citizen by birth, it is enough for the children, the offspring, the next generation to draw his lineages to the father. That's the legacy. Even in Assam also, we know all these issues. This
Only
is
the cut-off date is different.
correct. But can you say they're all right, your forefather might have been an Indian citizen by birth, but after 30 years, sorry, we don't recognize you. You have to come and show yourself, prove your citizenship or your localship or whatever afresh. If you do that, it is going to create a havoc for the person. It can be the case where somebody enters the territory subsequently or makes a fresh claim without any legacy. There you can take a stand like this for protecting the interest of the locals. We understand that. But what you're doing is you are driving a wedge in the family, in the lineage of a family where earlier they have been recognized as Sikkim subjects. Suddenly you drive a wedge saying that, okay, this much is okay. Henceforth, sorry. How can you do that?
Let me show the rationale. Let me show the rationale. My lord, I'm so thankful to your lordship to pinpointedly ask that. Let me show the rationale. Who were those people who were under service in Sikkim government prior to 31/12/1969? These are the people who were not included within 1, 2, 3, 4 Sikkim subject and their sons and daughters, people having agricultural land, people who have severed the relationship, any other part, they are residing for 15 long years. They do not conform to any of these. So the last, if you are son and daughter, I'm sorry, wife and child of a government servant,
Not child, minor child.
minor child of a government servant, who were the government servants? Government servants were the people, by and large, my lord, who did not have the other qualification, people coming from neighboring states of India, Nepal, Bhutan, China. Now, kindly see the exclusion clause. Sikkim, non-Sikkim how? We will give preference to Sikkimis and for the purpose of for direct recruitment and for the purpose of other things. So long we have Sikkimese national becoming eligible for the post, you will be phased out. Surendra Pratap, how did it come? Surendra Pratap was a case where a section of people were suddenly tell, Namaste, goodbye. They told that, why are you chucking me out? They told, we are chucking you out because by the proviso of sub-rule clause 4.4, our people have become eligible to hold posts. And as our people means locals are now entitled to hold posts, under this proviso, we will phase you out. They told you can phase me out only by way of, if at all, by way of seriatim in seniority. That's Surendra Pratap. Supreme Court says no. 4.4, there is told professed advantage for locals. So non-locals phase out in whatsoever manner the government thinks. That's how, and government took recourse to 4.4, and 4.4 is held to be valid. Now, my lord,
Mr. There, we can only show our respect to Surendra Pratap at this stage. Can't say anything more. Only our respect.
My lord, I remember, your lordship also remembers Jabalpur, ADM Jabalpur's case. We never even showed respect. This is one judgment, my lord, I see. My lord, my reverse senior, Mr. Datta, Nila Datta, lordship have not.
No.
He-
So fortunate.
My lord, he had a untimely departure from this world, not a timely departure. Anyway, my lord, he told me, find out whether ADM Jabalpur has been even referred to any other judgment of Supreme Court. My lord, I found, not to speak of disagreement, it was not even referred to. But my lord, Surendra Pratap is not one of those. Surendra Pratap, my lord, bows down only to constitution, nothing but constitution. It says, notwithstanding anything in this constitution, this is how 371F reads, and we cannot reread or rewrite it.
Sir, just a minute now, please. Apart from my brother, what I asked, this 9th of April 1981 memorandum,
Yes.
it speaks about 4 categories.
Yes.
Page 187.
My lord, my lord. Yes, my lord.
Is in modification of so and so, so and so.
My lord.
Please to authorize this 1970 government respect to following to issue certificates for employment in the state.
Yes.
Sir, these are the a person whose name found in the old Sikkim register, a person whose name found in the old Sikkim register, but he shall not so and so. A person whose agricultural land in rural areas, a person whose father, husband, service of government order on so and so.
Now, this is not under challenge.
It's not under challenge.
Yes.
Now, what was the occasion for the government to issue another notification in supersession of this 81 notification, wide notification 22nd of November 1995,
Hmm.
which which says a person whose father, husband has been so and so, certificate obtained by such person shall be for the purpose of employment only.
My
It
lord,
is in relation to, just a minute, sir.
Yes,
It is
yes.
in relation to a category number 5. Such categorization or such restriction was not there in the 81 memorandum.
it was
Then,
there, it was there.
no, it was not there.
My lord, kindly say.
That only for the employment purpose only. It says that this employment, the certificate would be issued to these persons. But there is no specification that in those certificates it would be, it should be mentioned that is only for the purpose of employment and no
My lord,
no other purpose.
let me have the privilege of reading it again to you.
Just a minute, sir. Then 1995, thereafter in 1996,
Hmm.
again, the government come with another notification says that the persons of this fifth category of person,
Hmm.
there would be a further stipulation that only for employment purpose and not for any other purpose.
This is reiteration of English, my lord, because we
Fine.
understand less English.
Again, and then 2010,
Yes, madam. Yes, madam.
this,
Yes.
this clause 4A,
Hmm.
another clause 4A was added.
Yes, madam.
A person whose father, husband eligible for grant of certificate under any of the categories, another one more category is created here, 4A and 5A, page 200, sir,
It's 200, my lord. Yes,
page 200.
4A. A person whose father name,
This another category was added.
my lord, it is just a reiteration of 1981.
No, another category was added that a person whose father, husband, earlier the person, fourth number of persons, 1, 2, 3, 4, they are entitled for COI. And again, they said their sons are also entitled for this COI.
It is there,
Yes, sir.
my lord. It is there.
It is there.
My
It
lord,
was not
it is
there
just,
earlier. 4A is inserted by notification dated 2010.
my lord, if your lordship allows me, I'll say it's the same old wine being put in different
So
bottles.
why, why you have inserted it when it was already there?
My
And
lord.
then clause 5,
Yes,
provided that no certificate shall be issued deemed to have been valid issued for the issue on the basis of relationship of parental grandfather, brother from the same father,
That's-
unless the appellant has established beyond all reasonable doubt, he or she at the time of citizen of India has been resident of the state. That was the occasion of adding all these things.
my lord,
particularly
very,
for-
very point. My lord, first of all, my lord,
And the learned single judge, maybe the judgment was not happily worded, or you can say,
my lord,
but the learned single judge has specifically observed that no noting or file of the state government which necessitated this inclusion, addition, or whatever it may be, are there. There's no justification for that. Simply sitting one day, you said, okay, these persons are entitled for employment certificate. And then you said, in one category, it would be, there should be a stipulation that only for employment. Then another day you say only for, not for any other purposes. What was the-
Arbitrary decision.
no, my lord,
There must be some reason for that.
my lord,
Where is that?
let me tell your lordships,
Yes.
with the elapse of time, this is a process which started, as your lordships have already seen, in 1976. I will maintain my stand even to reiterate to your lordships, my lord, now that 1976 and my lord, page 200,
2010.
it is nothing but putting the same wine in new bottles, only new shape, but the content remains the same. And why it necessitated? Because, my lord, ingenuous human brain, it started pilfering into the, my lord, holes and other things. So we met.
The tenor of the 1976 notice is memorandum or notification is the same. There was no need to issue this 2000 up to 2010 various
Because, my lord, the
notifications.
loopholes may not be, my lord, kindly see the use of English.
Show us the file where you find that we are facing difficulty in implementing this notification, therefore it is a requirement, a
No.
clarification
My
is
lord.
required, or something, some noting on the part of the government.
My lord, unreasonability is not to be tested on the basis of the executive notings that has gone beyond. If it is on the face of it,
Why
some,
why these clarifications are needed?
my lord,
needed,
let us,
you
let
have
us,
to at
no,
least
my lord,
some-
let us assume these are unnecessary. Strike them down. Just say 1976 and 1981 will hold good. Are they agreeable? Are they agreeable? This is the pivotal question which will answer everything. Let them answer. That 1995 gone, 2000 gone, okay. We agree to 1976, 1981, which is not under challenge.
You withdraw the appeal, the matter is there.
No, no, how can I? My lord, I'm a state. I'm not an, my lord, I have to understand from this honorable court, my lord, how, where do I stand? How do I administer my state? This states that it will not be henceforth for the purpose of employment. It will be for all purposes.
So
A written futility, do I exercise?
You're happy with this 1976 and 81?
Lordship, subject to what my senior said.
1976 and 1981, you have not challenged that.
Yeah,
at any
Baba,
point of
Bode
time.
Baba.
You are agreed by 95 notification, 96 and 2010 notification. And
We are deep
only that part has been set aside by the learned single judge.
We are deep citizens,
Only for the
78.
order of the learned single judge. Come to the order of the learned single judge, the operative portion. They have not challenged, they have not set aside the whole notification 95 or 2010 or
Yes, yes,
81.
only that, my lord, that one pointed out by your lordship. That is only.
Only these things. The insertion of the sentence certificate obtained by such person shall be for the purpose of employment only. This has been treated to be deleted or violative of Article 14.
First.
Another certificate of identification obtained by such person shall be for the purpose of only and not for any other purpose. This has been treated as a violative of Article 14 and therefore set aside. Letter bearing to the 26/2006. Item number 5. Third generation children of person who are issued certificate on the basis of employment of their father in the government is unconstitutional.
These are consequential.
These are the consequential orders. 2010 notification is consequential. So what he says, ignore all these notifications and 76 and 81 notifications which are not under challenge, they be declared as good. That's enough.
We begin with the premise that we have been deemed to be citizens.
Yeah.
Page 88, and it's the 812.
Yeah.
It says that we have been deemed to be citizens after that, after the cessation, after the coming.
1976 notification, 1981 notification, you are happy with that? There was no such bifurcation or I mean to say the isolation of yours. Classification, you can say. So there was no classification up to that time and you were happy up to that time. You are agreed by 95 notification, 96, 2010.
Yes.
And then the government says, ignore all these, whatever the
Relegate.
notifications, the position would remain as it was in the 1981. You would be happy by that.
Apparently, yes, because
Because the relief which the learned single judge is granted up to this extent only. Otherwise, the notifications have not been disturbed. Only some of the parts have been treated to be deleted or set aside.
But Lordship, may hear my senior before.
Mr. Day, you are not here till Monday?
So we take it, your argument as it is, that this 75 or 76 notification and this 81 notification, they be treated as a valid notification, other notification to you,
Yes,
you
my
may
lord.
ignore, or
Yes, my lord.
the government is going to withdraw.
My lord, because I understand, anyway, because it's not needed.
Needed
Yes.
without withdrawal, the how?
Yes. No, my lord, it's not a question of withdrawal. My lord, let me tell your lordships. Kindly don't take offense.
No, not that.
I am representing a client which is settled with the duty of administering the land as per the constitution. Honorable, my lord, I am neither here nor there. I am not a contesting party when it comes to the zone of employment. All right, none of my rights are in stake. I am puzzled, my lord, settled with this judgment. How do I administer my state? I don't invite a second Manipur. Let me be very precise on that.
So we are not intended to do all these things, and there is no question of that. But so far as regarding this learned single judge observations, that there was no justification to brought these amendments or further classification, which you have not been able to satisfy. They state for that, sir.
No, my lord, I will say that these are prima facie meant to.
And certainly these persons are not alien to Sikkim. They are the grandchildren and children of the Sikkimese citizens
Yes,
only.
and
They are not alien.
and their citizenship, and their citizenship is not under question. I again
Citizenship, they
say,
are citizen of India. They are not
absolutely.
citizen of Sikkim or Bhutan or whatever, Assam or something else. They are citizen of India.
Yes,
Their citizenship certainly is not under question.
no, this is not under question.
But ultimately, why this discrimination to these Sikkimese subject, Sikkim subject people? Because they
my
are
lord,
born and brought up there. They are not the persons who are coming from the outside the states.
no, they are coming from outside the state.
Outside the states?
Yes.
How can it be said they are the grandchildren and children of
No,
the
I'm telling you,
Sikkim
Lordship,
subjects?
they came from outside the state, and that's why, my lord, their lineage has been stopped at wife and child, and not to grandchildren.
So outside state.
Yes,
we fail to
because they don't
understand,
have,
sir.
kindly see, they do not fall under any of the 1, 2, 3, 4. They do not have land. They were not original Sikkim subject. They did not take up Sikkim nationality.
Unconfined.
No, my lord, kindly see.
Citizenship to only
Just
those
a minute.
four categories
No, my
of
lord,
persons, sir.
this is not
What about their
citizenship,
descendants?
my lord, kindly, not citizenship,
Just 1 minute.
local, non-local.
तो बाद में 1961 रेगुलेशन but they were concept these people are probably not local, but still
Yes, that's why the question.
ठीक बात है ये तो by issuing the notification they are opening the register of that's how it is not permissible.
And again, one more thing, I understand what is fallen from your lordships, that they were in Sikkim. If they were in Sikkim, their names must appear in the Sikkim register. None of their forefathers' names are there in Sikkim register.
Then it is a different thing.
Then it's a different thing. Then certainly they can't claim.
Yes,
Then
that's
they
the,
can't claim.
my lord, that's the issue.
Sir, then
Now we say, even
then-
if your
then-
names are not there,
then, sir, by allowing this writ petition and setting aside these few of the provisions or
post
lining,
1995, post 19,
how this is going to affect the state?
state,
Yeah, how it is going to be affect the state?
if we don't have a clarity from a judicial order, what does it mean? when-
There is a question of clarity. Certainly, we also agree on this, that no other, none of the grandchildren or children of a person who is not a Sikkim subject or who was not a Sikkim subject is not entitled for this relief what they are claiming to. these persons these persons are the grandchildren and children of the Sikkim subjects only. And they are asking this. And nobody else, sir.
No,
Sir, nobody else.
these are persons, forefathers of whom were never entered in the Sikkim register. Even their, not, I am not talking to parent, even their great-great-parents' names were not there in the Sikkim register. They were not
Sir,
a Sikkim
what
subject.
we were discussing, sir, this 1961, whatever this regulations,
Regulation.
as per those regulations,
Their forefathers have got the right.
just a, you have identified the persons who are originally from Sikkim. And with the exception, inclusion of one class, those persons who were serving with the Sikkim government up to 31st of December 1969. This is a class, another class which was included, decided to be included as Sikkim subject apart from original Sikkimis. And for whatever reasons, no other category of persons were included as a Sikkim subject or treated as a Sikkim subject at that point of time. And there must be a reason for that, because some of the persons were serving in the who are residents of Nepal, Bhutan, or whatever may be other countries of India. They were serving as a government servant in the Sikkim. Therefore, you decided that yes, include these persons also as a Sikkim citizens. So apart from original Sikkimis, you have also included this class of persons. And now their children or grandchildren, you say that you can't be treated as a Sikkim citizen. That can't be done, sir.
My lord,
That can't be done.
my lord, I am telling you, Lord. If they were government servants or their wife or children, they do not automatically become part of the register. They have to apply for it.
Mr. Dev, please.
Their names are not there in the Sikkim
Please
register.
hold on this. You please, I think some instructions are required here. This argument that you're making, prima facie appears to be a little self-contradictory. We say this because, see, this COI, even for educational purposes, by your own showing, can only be given to those people whose forefathers' name were in the register. That's the case of the government, correct? You can't give a COI to people who have entered subsequently, their citizenship they are in doubt. You can't give it.
Yes.
So either they have to be citizens of India, or they must have, through naturalization process, they must have incorporated into the territory of India, and Section 7, that notification covers them. So either ways, the argument that you're making that these people, their forefathers were never in service, that may not be entirely correct. Just have the instruction.
My lord, it's
Because-
not that they were not in service. I'm telling their names were not entered in the Sikkim register. Even after the new Citizenship Act came to force, citizenship order was promulgated, the committee was formed.
Then please, we'll invite your attention towards this opening para of the judgment. Impugned judgment. If this judgment, these observations are correct or not, you just know. The petitioner number 1 to 15 are the grandchildren of government servants to the government of Sikkim prior to 31st of December 1969.
Pausing for a moment, my lord. Please pause there for a
Just-
moment.
And another, the petitioner number 16 to 21 are the children of the government servant of the government on or before so and so, whether these statement is correct or not.
Let us assume that to be correct, although there is nothing in the records either to verify or cross-verify. I will assume them to be correct and then proceed.
Then what's the problem, sir?
There is
government
problem, my
servant
lord.
grandchildren who were in service prior to the 31st of December 1969, they were Sikkim subject. And the
No.
government servant who were in the government service up to 31st of December, they are also Sikkim subject.
No, my lord. My lord, these were qualifications with which a person subject to 1, 2, 3, 4 other things could apply for entering their name in the Sikkim citizenship register. Only because I'm a graduate, I don't get an employment. I have to apply for the employment, pass the exam. My lord, this is one of the conditions. If their names are there in Sikkim register, yes.
कोई भी यूजर का नाम डाल दे निकाल दे हो जाएगा कौन मेंटेन करता है ये रूल्स कैसे पता करेंगे क्या सही क्या वैल्यू हो सकता है कोई जेन्युइन आदमी था उसका नाम नहीं
My lord, by disturbing your lordships, let me add just one sentence. If the name of any of their forefathers, even great grandparents are there in Sikkim register, my lord, there can't be second opinion than what has fallen from your lordships. How can you deny it to his, my lord, sons, daughters, great-grandsons, or great-great-daughters? I cannot. Provided his name is there in the Sikkim register, not merely because he had one of those qualifications which gave him a right to apply for inclusion of his name in Sikkim register. My lord, a person's name has to be registered under the Sikkim register. And this process was continued post-merger of Sikkim. Lordship has seen 89 committee, 1990 committee, by which 70,000 and odd were again included. Included how? By a process of scrutiny of applications of those persons who had either of these 4 or 5 whatever qualification. They say they are sons and daughters of people who had served in the state prior to 69. I say, let us assume this statement to be correct. Where is the further statement that by virtue of these, their names were scrutinized and entered in the Sikkim National Register?
Mr. Since you are raking up this issue, we'll request you to come prepared on the next day on this point also.
I'm
See, just by saying we buy a register from the stationery shop and keep it somewhere and people put their name, that is going to have no, please listen, no bearing. If you want to rely so much on the register, you have to show us who maintained this register, under what authority of law, what has the procedure followed, was the names entered because people applied, or was there any survey made? If people had to apply, then what process was followed? Were applications invited? So all these things also you have to.
I will show. It is there, apparent on the face of this record. Lordship need not go further. We can show from the register. But yes, my lord, what has fallen from your lordship, I take it. I will come pinpointed right on.
Because now you are saying that now the point is, since their names were not in the register, that Sikkim register, and therefore the grandchildren or the children of those persons whose names were not there are not entitled.
Absolutely.
That is
Only because they have the qualification of BA, they cannot get the
Then
job.
why are you giving it to them for employment purpose?
Who, my lord?
You are giving it to them for employment purpose.
Yes,
Why?
because they are locals. And to be local, you must apply.
Oh, just
apply
now you
under
said
that
they are not
law.
locals.
Apply under that law. And there is a rule, regulation, how the application is to be made, scrutinized, appellate provision, carried forward in post-merger period, where committees are made, my lord.
Local, non-local.
Meticulous provisions. Committees are made by Government of India with Advocate General on, my lord, board. But let me tell, my lord, this is one terrain where in spite of changing gears, the car falters. The road is very bumpy. My lord, my lord, I tell your lordships, my first conference was with the Additional Advocate General who cannot come. I lambasted him with almost the same questions. But this is local, non-local business. But it took time for me to understand that citizenship issue and local, non-local issue are completely different. Everyone is a citizen. But out of the citizens broad category, there is a category churned out for employment and other privileged section where, my lord, by the merger agreement, as NBC standard 371A, my lord, a special provision was carved out to save the indigenous population of Sikkim being ravaged by others.
Yes, ये decision का भी record होगा. Mr. There, on the next date, can you please call that record which prompted this decision of only for employment?
Definitely, I'll call for this one. Definitely. Whatever is there, you can be placed before.
81, thereafter 95, 96,
yes.
2010.
What
Those
prompted-
relevant files.
What prompted them?
What prompted?
My lord.
And there was a opinion saying that those files were not traced out, and that is on record. And
Let them come and say that those files are not traced out. We'll see to it.
If she makes out a case for me beforehand, my lord, that is still better for me.
No, what she is saying that earlier there was a call for that record, and but at that time,
My lord, can it be in between 18, 19, 20th subject to losses convenience? My lord, I understand the special bench has to be constituted. 18, 19, 20th.
possibly.
It is a Wednesday, Thursday and Friday. Any of these days.
Not 18, 19, the 20th. Any other date.
My
apart
lord,
from this.
my lord, week starting 23rd also, my lord, any day subject to losses convenience. I think October will be by and large holiday. October. Any date, my lord, after the first half of. My predicament, let me tell you, my instructing counsels, father-in-law has to undergo, father has to undergo, my lord, kidney transplant.
Why don't you agree on a date, both sides? Just give it.
October, any date.
Yes, any date, any date.
Goes from the sixth before.
When you go to court, you.
No, that is very far away.
No,
We
then
take-
the
that is
3rd of
very
October, 3rd of October.
3rd of October, Just before the vacation, it is not possible.
My lord,
Because there are so many urgent cases.
my lord, for me, the ideal date would be 21st of October or 22nd of October.
And we'll fix it on 25th of October.
Yes, my lord.
25th of October.
And my lord, I can assure them, the driving licenses are not in stake. It is no one's case. My lord, we know ingenuity in advocacy is one of that part.
September would have been ideal, end of September.
Special bench has to be considered.
Today is only August, 1 month.
The 24th October,
Yes, my lord.
on hearing day,
Yes,
24th of October.
and I'll remember, my lord, the records.
ठीक है, that's right.
Plus, you will keep it part happen.
Is there?
I'm deeply obliged, my lord.
Thank you. Yes. Lordship, I'm really sorry, Lordship. There is a matter, Lordship, item number 15, your Lordship. There is item number 15. There is some urgency, Lordship. The urgency that it is also listed on 25th of October. No. Okay, then the bench, same bench, same combination you need then. No, Lordship, no, that I will not mention. Let it come, let it be as a leftover. Which matter you are asking for? Lordship, item 15 I was talking about. 15? 1-5, Lordship. 1-5. The tender matter, Lordship. I know there is no. The person is a visible person, your lordship, the petitioner. He has some anxiety, lordship. He is undergoing. Can't help, the bench is on 25th only. And lordship, let it be as a leftover, lordship. Let it be as a leftover.
Well, I think 22, madam.
24th September. Lordship, that will be too far, your lordship. And 24th September is not too far. Lordship,
I think 22.
okay, so 16th वाले week में. 16th September के week में.
Well, I think
Not surprised,
22,
not surprised.
taken up next week, madam. Any date, madam.
Whatever the date they are asking for, give them dates.
Mark.